permission, my lord.
Yes, Mr. Yes.
I'm moving two memos pertaining to two PIL matters. It has been earlier moved. This honorable court has directed me to move after the vacations. Now, my lord, both have been filed in the month of December 2023. It has not been come before this honorable.
Filed in December.
Filed in December.
Next week.
Please.
Pertains to cooperative election matter. Pertains to my lord, cooperative society selection matter, my lord. Petition was dismissed. My lord, sought for mandamus to conduct the election only for my lord, the vacant post. But you have the judgments of the other learned single judge. My petition was dismissed. They are going to conduct the elections, my lord, fresh elections for the entire cooperative society.
Remove the office of objection listed.
Yesterday I am fine, my lord. Till today, my lord.
Not by memo. Yes.
Lordships kindly, your lordship. One matter, your lordship, dismissed for non-prosecution, your lordship. I have made the application, your lordship, long back, because it was dismissed from the registered judicial order, your lordship, and I made the application to recall it. For mining case, your lordship, forest department case, your lordship, which comes before your lordship. For recalling the order as well as for my admissions, your lordship.
First court
Yes,
dismissed
yes.
the want to proceed
Forest matter comes before your lordship.
recently. When it was dismissed?
Dismiss, your lordship, is 5 months back, your lordship, it was dismissed. Then I made the application.
To be listed within 3-4 days.
Your lordship, one contempt may
List it within 3-4 days. The application for restoration.
Your lordship, one contempt matter. What happened is, your lordship, that the Dishonorable Court directed the respondent to issue the caste certificate. Your lordship, I got seat in NLS Law College. But what happened is, if I does not produce the certificate, the caste certificate before 31st of this month, my seat will be cancelled. Therefore, I filed, in spite of the direction issued by this honorable court, they are not issuing the caste certificate. My father also belongs to, I produced the documents.
Admission.
My lord?
Admission.
Yes, your lordship, admission. If I doesn't, because I cleared the entrance exam. So if I doesn't produce it, they'll
When
cancel.
the exam is scheduled?
Exam is over, my lord, because only thing is that I'll have to submit the certificate to,
Monday, next Monday.
could it be before that? Otherwise, well, 31st, they have sent an email saying that if you doesn't produce the certificate, this is on next Thursday.
Day after.
Yes, your lordship. Please, your lordship, I'm grateful.
May I request
My lord,
Yes.
contempt proceedings, my lord?
2016 matter, my lord. So interim orders granted by the honorable court subject to payment of royalty to the Department of Mines and Geology. Based on that, we have paid the royalty and we have obtained the legal permit, my lord. Subsequently, in the year 2022, my lord, suddenly they have stopped the permits, my lord. Based on that, we have filed application for disobedience of the interim order, my lord. I have filed the application in the March 2024, my lord. As permit me to move an application for being an EMI.
You will learn a single judge.
No, my lord, it is before the division benches. Nice matter, my lord.
Since 22 it is hanging.
My lord, 2016 matter, my lord.
Then you moved an application 22.
My lord, the application is, they stopped the mining permit in the year 2022, my lord. Subsequently, we have made a representation, we have given legal notice, and 2020.
Not a case for, will be listed in the regular course within. Get it listed. No memo. Yes.
my lord, this petition in respect of 2 workers who died while cleaning a manhole, my lord. 10 lakhs had been deposited by the employers on the directions of this court. My lord had directed for the dispersal of that amount to the legal representatives. The office, my lord, has raised an objection that the application for bringing the LRs on record is still pending, and therefore they will not be able to disburse that amount, my lord. So the matter may be posted for that application so that that application could be.
By mistake, it must be pending.
I'm sorry, my lord.
The application to bring the.
Please, my lord, it's still pending, but an order was passed to disperse the amount. But the officer said that since the application is pending.
Get it listed. We'll pass.
Please, my lord, another matter for contempt, my lord, which was filed in February. It's post.
This application may be listed for bringing it. It is already listed on to be listed on 10th. So it is already to be listed.
My lord, it is posted on 10 June, my lord, but there is a bit of difficulty for the families, my lord. That's the reason I have posted this. My lord, a contempt petition, my lord, which we filed in February, it has not yet been listed, my lord. Any date may kindly be given.
It will list it. Wait.
Lord,
No
the
memo.
contempt proceedings was not kept in abeyance by the honorable court. But the apex court, my lord, has clarified to go on with the contempt proceedings. The order was challenged before the apex court. An order is available. Despite the specific direction by the learned single judgment, the authority not complied before complied the order. We have filed the contempt proceedings before this honorable court. My lord. The contempt proceeding, this honorable court held that, my lord, till the disposal of the appeal, the contempt proceeding was kept in abeyance. That order was challenged before the apex court. My lord. Apex courts clarified to go on with the contempt proceedings. But there is a specific direction that to go on with the matter. Art is available, art is also produced. Apex court art.
So when it is contempt is going to be listed?
Not contempt proceedings is not kept in abeyance because not the trial court, the appeal is pending with the trial court. That order we have challenged before the honorable
So
appeal.
file an application to get the contempt listed on the basis of this order, not by memo.
Please.
Not a contempt matter, my lord. For hearing before charge.
Pardon?
Hearing before charge, my lord. What has happened is 2010, the complainants were dismissed illegally from service. They had gone to labor court, my lord. Labor court had transferred for reinstatement for those people. And before the single judge, my lord, before the single judge, the university had held that, stated that they will appoint in 3 months, my lord. It's been more than 1.5 years, my lord.
So what do you want?
My lord, kindly be listed for hearing before charge, my lord. They have not filed any. They kindly be listed for hearing before charge.
Date is given or not?
Date is not given, it was.
After 2 weeks.
My lord, one writ appeal, my lord. The matter pertains to tender. I am the respondent number 1. The interim order is operating against me, my lord. My request for any date, my lord. Matter pertains to tender of medical equipments, my lord.
Then
I am the
some
successful bidder.
some date must have been given.
My lord,
Some date must have been given in the main petition.
my lord, it's after 2 weeks, my lord. 15/6.
Tender matter to come before on a single judge, not the.
No, my lord, it was disposed of, my lord, with a direction to issue purchase order, my lord, against which tender calling authority has preferred writ appeal, my lord.
So it is
There is
written.
interim order of stay, my lord. Interim order is operating against me, my lord. I am the successful bidder.
File IA, not by memo.
I have filed IA for vacating stay, my lord.
Then let it get it listed after 10 days.
Please, my lord.
IA.
IF for hearing on IA, my lord.
Yes.
Please.
Your Honor, I have a small submission. We have filed this civil contempt of in February 24. It's not listed.
Little louder with mic.
Your Honor, this civil contempt we filed in 2024 Feb, but it's not listed. The accused not complied with the this honorable court has already. The accused has not been paid the compromise. The accused not has been paid the amount as per the compromise of the honorable this court.
You are neither speaking English nor Kannada.
And little bit nervous. Sir.
Come against mic so that we can catch your words. Yes. What do you want listing?
Sir,
What is the request?
any date of this month, Your Honor. Any date.
What is? Contempt. It will be listed. Don't worry. We'll see that it all are listed. Wait for a week, then mention. Yes, madam.
My lord, one writ appeal, my lord. ಇದರಲ್ಲಿ ಕಂಟೆಂಪ್ಟ್ ಇದೆ. ಸಿಂಗಲ್ ಬೆಂಚ್ ಮುಂದೆ 6 pay commission ಗೆ ಆರ್ಡರ್ ಆಗಿತ್ತು. However, she is not entitled for it. Now she filed a contempt on it. ಅದರಲ್ಲಿ 3/6 ಗೆ ಲಿಸ್ಟ್ ಇದೆ ಮ್ಯಾಮ್. ಬಿಫೋರ್ ದಟ್ ಈ ಮ್ಯಾಟರ್ ಲಿಸ್ಟ್ ಆಗಲಿ. ಇದರಲ್ಲಿ CC ನಂಬರ್ 22624 ಗೆ 3624 ಗೆ ಲಿಸ್ಟ್ ಆಗುತ್ತದೆ.
Next Tuesday.
Tuesday. Third, my lord, before third.
Before third.
Yeah, my lord, before third.
Why?
Second of June.
Why before third?
My lord.
Why before third?
A contempt matter, it is listed on 3624, my lord. Before that, namige matter.
Contempt matter is listed when?
3/6/24, my lord.
3/6, list on 3/6. Yes,
May I request for a short accommodation, item number 7, my lords.
item number
7, my lords.
7.
To produce few documents, my lords. For a short accommodation of 1 week.
Why do you want?
I want to 5 minutes, I along with additional documents, my lords.
2 weeks
Grateful.
at the request of learned advocate for the public interest petition, 10 to 7th July. Not 8th July.
Grateful.
Eighth also holiday. No, July. July. No, July.
Actually, your lordship ordered notice on 23/4/2024.
Notice returnable on 8th July.
Seal number 2, Mahesh.
My lord, seeking permission to withdraw the instant petition, my lord.
This is your drawing.
Yes, my lord, withdrawing the instant petition. My lord,
Learned-
there is a memo. May
Learned
I-
counsel, Miss, what is your good name?
Usha S. Nair.
Usha Nair for learned advocate, Mr. Mahesh Srikant for the contempt petitioner, 6 permission to withdraw
Yes, my lord.
present contempt application. In that regard, some file is filed, withdrawal post. In this regard, learned advocate invites memo of withdrawal dated 28/5/24, filed on the record of the proceedings, which inter alia instructs which inter alia mentions that any of the subsequent developments, the petition is being introduced. Dispose of is not, dispose of is withdrawn.
My lord, may I also seek a liberty to file a fresh petition if a fresh cause of action arises?
It goes without saying that the
I make one submission, my lords.
any
My lords,
development and for,
one submission, my lords. Permit me to file my wakalat to the accused, my lords.
you can file always. You also learn advocate, Mr.
Karthikeyan, my lords.
So is permitted to file his wakalat now on behalf of the respondent.
Not so much, my lord.
Yes.
Seal number 3, Mr. Chetan Kumar H.
My lords, I appear for the complainant. The accused had given an undertaking before this court, my lord, that he would vacate the handover vacant portion of the property to the complainants on or before 28th February 2024. So far, he has not handed over the vacant portion, my lord. There is willful breach of the undertaking given by him, my lord.
Which order you want to comply?
My lord.
Which order is under contempt? Which are the directions to be complied?
My lord, page number 15, my lord. He has filed an affidavit, my lord.
Page?
Page number 15, running page number, annexure C. He has given an undertaking, my lord, in the affidavit filed by him, para number 3.
So this is filed pursuant to terms of settlement.
Yes, my lord. Yes, my lord.
Now, this affidavit was filed pursuant to some direction.
As per the orders passed by this court, my lord,
Where is that?
on page number 10, Annex A, my lord.
Page number 10.
10, my lord. Running page number 10.
Where the direction is filed? Where is the direction to file affidavit?
Page number 6, my lord. Para number 6, my lord.
Para number 6. Where is?
My lord, para number 3, sub-para number A, there is a clear direction, my lord. There is a.
This is the learned oath, both the sides jointly submit that the parties have agreed as follows. This is an agreement recorded.
Yes, my lord. Based on this basis.
Where is that? My
Yes,
brother
yes.
is rightly saying that there is no, this affidavit is not pursuant to some direction of the court. Nor you can connect it with this order when it is independent. So, when it is not connected with any order of the court.
But he has filed the affidavit.
Say that there is a contempt.
He has
This
filed
is simply an agreement recorded.
My lord, he has filed this undertaking before this court, my lord. My lord, there is a breach of undertaken given by him to this court, my lord. Therefore, it amounts to contempt, my lord.
Court is never directed to give undertaking. Nor the order of the court records that the parties shall find silent.
But my submission, my lord, is that he has given an undertaking before this court, my lord, by way of an
There are
affidavit.
other remedies, not contempt.
My lord, civil contempt is defined like this, my lord. Civil contempt means willful disobedience to any adjudgment, decree, direction, order, writ, or other process of a court, or willful breach of an undertaking given to a court.
Therefore, I humbly pray. This is at the disposal. So in any case, we are not inclined, Mr. Can't be brought under contempt.
My lord, it comes under the definition under section 2, clause B, my lord. Clearly, it comes under the definition.
Clause B. Now, there is unfortunately, there is no direction in the order. Either to file affidavit or that the parties shall comply with what they have agreed. Abide by what they have agreed.
He has filed an affidavit, my lord. before this court, she has filed an affidavit undertaking to vacate the interim premises on or before 28th of February.
Show some judgment that this can be brought under the contempt jurisdiction.
I beg your pardon.
Show some judgments if they are available. In the moment, we are not inclined to exercise the contempt jurisdiction. There is no direction, nor the affidavit can be connected to the order of the court in absence of any. Find out some judgments. 3 weeks. Or in the meantime, you want to exhaust some other remedies, you do it. Because next.
Here 24-6, seal number 4 PL matters. Special
To Lordship's kind permission, but I need a short accommodation in this matter. 1 week time is quite good. I need 1 week time, not to get because the party is not prepared to engage senior counsel services.
Parties
not prepared to engage senior counsel. That is the reason. I need 1 week.
This is the matter where senior counsel must have been engaged in the very first day. Ms. Nilofer is understanding what we are saying.
Sorry.
This matter can't be argued to the senior. The very first day you must bring a senior. What is this? What kind of public interest are bringing? This is a notification altering the limits of the or making it transitional area.
Please.
A statutory notification. What is?
Without following the due procedure plan,
What due
procedure mode of contempt under section 9, but they have not followed.
What? Hearing.
Hearing and consideration of objection by the governor. But here is a case that the Director of Municipal Administration, having received the objection, has sent it to Deputy Commissioner instead of forwarding it to the governor. That is what the provision says. That there is a clear case of procedural lapse on the part of the authorities.
Invited objections are invited.
Objections were invited as per Annexure B. We have submitted Annexure D, E series, which the authority having received the objection would have forwarded to the There are 2 judgments that are produced along with this writ petition. This honorable court
File your objections, notice returnable on
Not, I take notice for respondents 1 to 5 and 7.
9th of July.
1 to 5 and 7.
Additional government advocate, Ms. Nilofer. Accepts notice on behalf of criminal 1 and 2.
1 to 5 and 7.
1 to 5 and 7. Nilofer Akbar, yes.
Notice will have to go to R6.
Yes.
Number 5, okay, Amrita.
Lordships, I appear for the petitioner. This is public interest litigation where the petitioner pray for direction to the respondent to take strict and stringent actions against the continuous encroachers and unoccupied, unauthorized occupation on the government land. It is a minor forest categorized as minor forest and Sopina Betta in the Alagiri village of Tirthali Taluk.
Have you gone to the, before the authorities?
Your Lordships.
Have you applied or make representation?
Yes, Your Lordships,
There is-
continuously,
Then you,
we had given the, even the
No res-
notice also has been,
there is no response.
there is no response, Your Lordships.
My lord, I'll take notice. My lord, the prayer may be seen, my lord. Action is to be taken against the encroacher. The encroacher is not made a party.
Your Lordships, it's not one or two, it's only an example.
10
It's a
gundas.
public interest litigation because in the interest of public.
My lord, I'll take notice and I'll get back to you. Regard to the number of encroachers.
Your Lordships, it's one,
We have not received notice. Why, how can you take?
Just to assist my lord, that's all. Because they say for 10 gundas, one person has encroached and that encroacher is not made a party.
Your Lordships, it's a public interest because it is a privilege is should to be given to the
Party
villagers.
against whom direction is sought is not a party.
So,
Party against whom direction is sought is not a party. Is not made a party.
Your Lordships, this has been filed at large. It's, I mean, one or two, I mean, it's only one person has been highlighted. Other, I mean, I have come to know that some others also are doing this. And this should not become a precedent if it continues like that. That's why this PIL has been filed, Your Lordships. And government, I mean, the respondent has to take the stringent action. It's not pointed to one person or something like that. He has cut valuable trees, medicinal trees, and he has excavated the earth, the soil also he has taken of 30 feet.
In this public interest petition, what is alleged by the petition? Inter alia is that land bearing survey number 16 of about 150 acres of minor forest and Sopina
Betta.
Sopina Betta of 65 acres and 23 kuntas at Shivam Goga district, Tirthahalli Taluka, Kasabaholi, and Elagere village, which are government lands whom I have been encroached upon to the extent of 10 gutas by one Mr. Uma Pathi, PATHI, son of SHE, SHA, PARAIHP, page 2 per. It is also the allegation that the plantations on the land in the nature of which include the medicinal trees have been excavated and removed. The petitioner has stated that a complaint is given to the authorities about this act of encroachment and illegal excavation, etc. However, no action is taken. When it was pointed out that don't write at this stage learned advocate for the petitioner so and so seeks permission to add the above named encroacher as party in the petition, party respondent in the petition. Necessary amendment will be carried out in the course date. There shall be notice to the respondents. Full stop. The reply shall be filed dealing with the allegations of encroachment before the next date to be listed on 10th of July. Learned additional government advocate, Ms. Nilofer Akbar accepts notice on behalf of all the respondents.
Number 6, to J.R. Mohan.
There is no petition. My lord, in this writ petition, I have sought for a direction to the respondents to consider my representation for holding inquiry for the inordinate delay caused in constituting a department committee to the third respondent institution. My lord, in order to secure transparency in public procurement, the state government has enacted the transparency in procuring the Transparency in Public Procurement Act 2000. Pursuant to this Act, my lord, the state government has issued a circular dated 29 January 2022 by Annexure A, directing all the departments to constitute department committees. The purpose of formation of this department committee is to bring to book the corrupt tenderers.
There is no department committee.
My lord,
Department committee is not
Yes.
constituted.
my lord, it's been constituted, but he wants to know the reason for the delay, my lord.
It is constituted.
Yes.
Yes, my lord. It is constituted, but
Not entered.
there is a inordinate delay, my lord, in constitution. The two, my lord, I have submitted the application under Right to Information Act. Only after receipt of that application only, they have constituted the department committee. Had I not filed that application, even to this date, they would not have constituted the committee. There is deliberate delay, my lord.
Our learned advocate, Mr. So for the petitioner and learned additional advocate general, Ms. Nilofer Akbar for the respondents, claiming to be a social worker and further claiming that the petitioner has no personal interest, this petition is filed seeking a prayer to hold inquiry, to direct the respondent 1 and 2 authorities to inquiry, to hold a detailed inquiry for delay in constituting the department committee by Respondent 3 as the managing director of Karnataka Rural Infrastructure Development Limited. It is stated by the petitioner that the representation dated 15/9/23 has been made, seeking the explanation about the delay in constitution of the committee, but the same has not been responded to. Most of the basic grievance of the petitioner sought to be voiced in the petition is that there is a delay in constituting the debarment committee by Respondent 3 under the provisions of the Karnataka Transparency in Public Procurement Act and Rules. It was stated that the government circular was issued on 28/1/22, providing for constitution of such committee. First of, in course of the hearing of the petition, it transpired and became an admitted fact that the debarment committee under the aforesaid statute has already been constituted.
Let us interrupt, my lord. My lord, it's at annexure D. My lord, it's dated 14/7/2023, page 30.
Already constituted on 14/7/2023, full stop. The petitioners complains that there is a delay in constitution of the committee. Full stop. The court is of the view that such a grievance cannot be agitated in the public interest litigation, only for seeking the grounds for delay when the committee is already constituted and has become functional. Full stop. No case is made out for interference or granting any relief in this public interest petition. Dismissed.
Seven adjourned. Green bench matter, still number 8, Srinivas C.
I'm appearing for the petition in this matter. This matter, my lord, we are challenging the demand notice dated 14/3/2022, annexure E and F, my lord, without providing an opportunity to the petitioner and without conducting the drone survey as per the Rule 40 of the Karnataka Mines and Minerals Rules. Similar identical matter, my lord, it's this honorable court is allowed the writ petition and set aside the demand notice and direct the respondent to conduct the fresh drone survey and issue a demand notice fresh, annexure J, my lord. And pursuant to this order, my lord, this honorable court once again held by this honorable court in WP number 29/3/26 of 23 on 8th January 2024, my lord.
What are you saying?
Pursuant to the annexure J, my lord, the similar order is passed by this honorable court on 8th January 2024. Very same adjacent land, my lord.
It is there on record. Same.
No, my lord, it's pursuant to annexure J, my lord. This order is pursuant to annexure J.
See, it is already on record. 14th September. News. Yes.
Would Annexure F is the demand notice which they have challenged, which is dated 14/3/22, my lord. Subsequently, my lord, there is one more demand notice which is issued on 29/4/23. Annexure F is dated 14/3/22, my lord. Subsequent to that, my lord, there is one more demand notice which is issued, my lord. Lordship can kindly produce. It is dated 24/23, my lord.
That is after hearing.
After this writ petition, my lord.
Yes, so So what is the relevance of this?
I beg your pardon, my lord.
What is the relevance? What is the relevance of this subsequent note?
My lord, my submission is that, my lord, that the petitioners challenge this demand notice. They have an alternative remedy under section 53 of the Act also.
But madam, this court has passed the orders remitting the bill. You find out whether this impugned notice is without hearing them.
Please, I will.
My lord, kindly turn to page number,
Remedy is available
Yes, ma'am. 53, my lord.
against notice or order?
Yes, please, ma'am.
This is notice,
Please, ma'am.
53.
Please, ma'am.
Agreed by order of the competent. So this is an order or notice?
Competent authority, my
it's
lord.
competent authorities,
Not
my
above
lord.
the rank of additional director.
No, it says that any person agreed by an order of the competent authority. So this is an
This is
order or
only
notice?
demand notice.
Yes, my lord. Senior geologist. The order is passed by the senior geologist.
This is an order or notice?
Notice, my lord.
Then it's final order. So only the authorities are the parties or any other parties?
No, my lord, it's only authorities are parties.
This is considered, as my brother is rightly pointing out, in the division bench judgment, this aspect. So when there is a breach of natural justice and they are not heard, the God has exercised the writ jurisdiction, nothing wrong in it.
Yes.
So we'll pass the order on the same lines.
Please, my lord.
We are sending back,
Yes.
decided
Please,
within 8 weeks.
please, my lord.
Yes, for.
Much of.
Number 9.
Excuse me, Lord. The petitioner before your lordship filed an application for grant of quarry lease in the year of 2008.
Yesterday's matter is there.
No, this is different. 2008 at document number, page number 18 for grant of quarry lease. Subsequent to that, after compliance, my lord, notification has been issued by the Department of Mines and Geology granting quarry lease as per my lord, page number 25 Annexure B. Annexure B, notification has been issued. In page number 25 is the notification. Thereafterwards, my lord, Annexure C, in page number 28 may kindly be seen. I have paid entire amount which is to be required to deposit before the Mines and Geology Department. They have through DD, and they have received. Subsequent to that, my lord, that they have not executed quarry lease, and 2010, my lord, this notice has not, that is throughout my contention. This Annexure D in page number 31 came to be passed, and no, this order has not been served. And the subsequent to that, my lord, I have filed application under RTI. Immediately after receipt of that, I have approached, my lord, revisional authority under 53. That is in page number 42, Annexure G. I have taken specific contention that that order dated, my lord, 2010 has not been served on me. Then I have filed the application in RTI and obtained, and immediately revision petition came to be filed. Thereafter, my lord, the revisional authority passed order, my lord, rejecting my revision petition, holding that there is an amendment in the year of 2016. Therefore, my lord, I am not entitled. The operative portion I may permitted to read. Order in page number 51. If, my lord, Mines and Geology Department is able to establish that that notice has been served to me, if entire record called for, my lord, if it is served in the year of 2010, yes, my lord, I am not entitled because I have to challenge within stipulated time. My specific contention is that no notice has not been served. If your lordship call for entire record, then if, my lord, there is a acknowledgement for serving that order which I have challenged.
How did you come to know about this order?
Please, my lord.
How did you come to know?
2021, when I have approached for execute the delay, and then they have given this order. Immediately, I have approached revisional authority under 53. And this honorable court considered calling for record this on.
One of the contentions of the petitioner. It is the contention of the petitioner that
up. And there is a procedure also for cancellation of notification.
the request of the petitioner was for for sanction of Quarry lease was rejected on 28/1/2010. However, the said notification was never communicated to, was not communicated to him. So therefore, the petitioner could file the revision petition against the aforesaid rejection only on 8/12/2020. In this light, it was submitted that the ground of delay of 10 years which weighed with the revision authority in rejecting the revision, in dismissing the revision application is not well founded. Full stop. Notice is issued for the limited purpose, requiring the respondents to apprise the court actually on the aforesaid
10 years.
aspect only.
Yes, ma'am. With great respect to this court, if it is served, I have no case.
Then we'll go further if you are.
Please.
The return about.
10 months delay, sir. 10-year, 10 months delay, sir.
We know that.
I have
He is saying
clearly
that the
stated.
order was not served. So we found out from the record and tell us what is the actual position.
I'll take notice and seek instruction.
Return 10th July.
Please. The notice may be ordered.
Learned Advocate Miss
Sarita Kulkarni. Sarita Kulkarni.
Sarita Kulkarni. Learned Additional Government Advocate Ms. Sarita Kulkarni. Accepts notice on behalf of
All the response.
Much.
Number 10, Abhijit, yes.
My lords, I represent the petitioner here. The petition is filed seeking direction to respondent number 3, my lords, to consider the application filed by petitioner, that is a stone quarry license application, annexure B, my lord, page number 25. Said application is filed on 23/5/2023 and it is still pending. Thereafter, I have made a total of 12 representations to the concerned authorities for consideration of the application. Yet no steps have been taken and the application is still kept pending.
you are appearing to consider the application. This much we can direct, nothing more. Heard learned advocate Mr. So-and-so for the petitioner and learned additional government advocate Ms. Sarita Kulkarni for the respondent authority, respondent state and its authorities. Record under Article 226 of the Constitution, comma. Participate in this petition is to direct the respondent 3. Senior geologist, Karwar, Uttar Kannada.
Uttar Kannada.
Now please don't interrupt. To grant stone quarry license to the petitioner. As per the application made by the petitioner on 25/5/23. It is the case of the petitioner paragraph that that the petitioner has applied for granting of ordinary stone quarrying license in respect of area of 4 acres out of 4 acres and 38 guntas in survey number 43 capital A oblique 195 plus 196 plot number 340 at Ramnagar Padalli village Taluka Choida district Karwar. It is further stated by the petitioner that when the petitioner received letter dated 23/5/23 from respondent 3 informing that respondent number 4 and 5 are asked to conduct inspection and that no inspection was carried out despite above, a further representation was made on 3/10/23 requesting for conducting of inspection and issuance of no objection certificate so that the license for the quarrying could be granted. Paragraph. It is the grievance of the petitioner that the respondents have set tight over their application. Dated 25/5/23 and no response have been forthcoming, no inspection is carried out as already required. Full stop. When the application of the petitioner for grant of stone quarry license is already pending and the amendments made by the petitioners themselves suggest that the authorities have to some extent activated themselves in response to the application of petitioner, it would be appropriate to dispose of the present petition by directing the competent authorities of the respondent to expedite the consideration of the application of the petitioner. Accordingly, respondents are directed to act through their competent authorities, consider and decide the application of the petitioner dated 25/5/23 strictly in accordance with law and on its own merits, so as to decide whether the petitioner is entitled to be granted the license for the quarrying lease on the land in question. Petition is disposed of. Such decision before that. Such decision may be preferably taken within 12 weeks from the date of receipt of the order.
Question number 11. Mr. LM Chidanandaya.
Application under 31 ZC is filed, seeking grant of quarry lease, my lord, is a plant which is manufacturing M sand. My lord, the application itself is not moved in.
There is also 90 days have gone. They are saying that 90 days is the period contemplated. Which rule? Some rule or some section?
Connected matters, your lordship.
Rule 31 ZC.
Yes.
So 90 days are contemplated there within period.
That this is under the that I have extracted 31 ZC. That this is under rule 22, my lord, which I have extracted.
Yes, what do you say?
Instructions. I'll seek instructions.
Let your lordship.
I'll seek
this one.
instructions.
Take instructions.
Please.
Your lordship connected matter, same petition, my lord. Your lordship granted them 6 months time.
Disposed of on the same lines. Consider and decide. 90 days period was a statutory mandate under rule 20.
Please.
It has passed away. You decide now. What are your instructions?
But I'll seek instructions. It may be taken. It may be taken tomorrow.
Tomorrow.
Please.
All right, tomorrow. Tomorrow.
Connected matter, reason given was, my lord, about 1,500 applications were received. Therefore, they were not able to process well. In the connected matter, that's a target reduction.
What instruction will you take tomorrow?
Number of applications received were more. That is the.
Number of applications received were more.
Yes.
That is the reason your lordship granted 6 months.
Whatever you want.
May be taken at 2:30. 2:30.
No, you can have time tomorrow, not if.
Tomorrow, please.
Tomorrow.
Question number 12. Mr. S.Y. Sivaldi.
Notice number 12 and 13 relating to deemed conversion or carrying on quarrying operation. These two matters are not identical.
95A,
95-9. 95-9. But a
Same
similar
order.
matter was listed yesterday.
Same order.
Same order.
Who will appear? Who will appear? You will appear. We will dispose of as per the direct.
Please.
Several orders are passed.
Already produced along with the election.
But we will add that if otherwise he is entitled. Merely because the application is made, you examine on merits. His application for conversion on merits. And if it is otherwise grantable, then intimate about the fine payable. That much will say, that much will say. If otherwise you are entitled.
For a coring operation, there is a provision that redeemed conversion. The moment application is.
No, but there might be several one to host of the aspects which may be
If the
entitled.
license is not granted, my lord, then this.
Subject to
conversion order
obtaining
will not
license.
have any effect.
Subject to obtaining license.
Yes, yes,
Subject to obtaining. That is what the order of this honorable court. I have produced. more.
on the same line.
12 and 13. 13 also. Writ appeal matters, cell number 14, Mr. Sanjeev BL.
Content.
Lord. Respondent, my lord, was appointed as a Budley driver. And he was appointed on 7/7/1993. And he was made probationary on 13/1/1998, my lord. Later on, my lord, he was confirmed on 8/9/2000, my lord. Now, my lord, the respondent, my lord, on 30/7/2012 raises a dispute claiming his time scale, my lord, for the time 7/7/1993 to 16/8/1998, my lord. After a delay of 14 years, my lord, 14 years, my lord.
He was in service.
He was in service, my lord, but he had only made representations, my lord, but he had not.
If he is otherwise entitled to, then delay will not come in way once he was in service.
Yes, my lord.
And learned single judge said that he is otherwise entitled under the.
Yes, my lord. On merits, learned single judge says he's entitled for that.
What is your good name?
Srinivas BS.
Dismissed. Okay. Sorry.
Number 15.
Sridhar
Narayan.
This writ appeal is made against the order passed by the single judge dated 24/11/2023. The writ petitioner was an employee of the appellant company. My lord, he was serving as a guard. My lord, while he was serving as a guard, my lord, in the year 2012, that is on 9/1/2012, my lord, he committed a misconduct. He stolen the, my lord, material belongings to the company. My lord, consequently, my lord, the domestic inquiry was initiated against him by issuance of the charge sheet dated, my lord, 25/8/2012. And my lord, the inquiry was conducted. And my lord, the inquiry report was submitted. And thereafter, my lord, second show cause notice was issued to him. And my lord, the penalty order was, my lord, issued against him. My lord, penalty order dated 2/3/2018. My lord, withholding 3 increments cumulative effect. And suspension period was confirmed. Against that, my lord, he approached the learned single judge by way of filing the writ petition. My lord, learned single judge, my lord, allowed the writ petition in part. And my lord, modified the penalty order. The reason assigned by the learned single judge is.
I learned single judge substituted penalty on what ground?
Please, reason assigned by the learned single judge is, my lord, the authority.
That
Why-
disciplinary authority did not assign any reason.
did not consider the reply of the petitioner to the second show cause notice. And the learned single judge.
It was, the endings were recorded by the inquiry officer in respect of guilt.
Please, second show cause notice. No,
Disciplinary authority agreed with the finding.
in fact, in the
Disciplinary authority agreed with the finding of the inquiry officer.
inquiry report.
Disciplinary authority agreed with the finding of the inquiry.
Agreed with the,
Please.
please. Then it is not the mandate. That is what my case, my lord. If there is any disagreement with the inquiry report, my lord, the reply given by the employee has to be, my lord, reason has to be assigned while issuing the penalty order. There is no disagreement, agreement with the penalty inquiry report. And my lord, moreover, my lord, the single judge, my lord, at best, my lord, could have been remanded to the authority, since only the reason assigned by the single judge.
We'll admit the appeal,
Please,
but
please,
we'll not grant any stay.
My lord, stay is, my lord, in fact,
Having the appeal at this stage, therefore.
and he may persuade for
Retired
implementation of the single judge order, my lord. That is the.
In principle, you are right, but let us heard learned advocate Mr.
Please,
So-and-so
oblige.
for the appeal.
There is a delay of 34 days.
Stay is there.
34
You are
days.
appearing?
A short delay.
Appearing for-
Appearing
For delay, I have no objection. But Annexure F, you lost.
Appearing for whom?
Admitted amount, my lord,
You are appearing for
for the workman.
workman.
Let-
So order in IA. Heard learned advocate Mr. So-and-so for the applicant and learned advocate Mr. Respondent original petition. Delay of 34 days has occurred in preparing the present writ appeal against judgment and order of learned single judge. Full stop. The supporting affidavit spells out the reasons for passage of time leading to the delay to the aforesaid extent. Full stop. The grounds given make out sufficient cause to condone the delay. Wherever delay is condoned, the application is allowed. In appeal, heard so-and-so the appellant and learned so-and-so the respondent. Appeal is admitted. It will be open for the parties to file interim application for fixing the date of early hearing of the appeal after passage of reasonable time.
May I pursue for an interim order. May I pursue for an interim order of stay of the learned single judge.
Although interim leave is pressed for by learned advocate for the appellant, it cannot be granted for the simple reason that granting of any relief at this stage would amount to allowing the appeal, which is not permissible in law.
Please, please.
Number 16, the Nagraj.
My lords, this honorable court on the last date of hearing, my lords, had directed the state government to give the schedule for the elections. I may be permitted to place the schedule on record.
Give to the your learned.
For the cooperative society, my lords.
He is furiously asking.
Lords, your lordships may kindly see the operative portion of the orders of the learned single judge, which is not challenged by the state. The state required to hold the elections on or before 25th of July 2024. They have the audacity to come before the court and say that they want to hold the elections during October 2024. It will be in clear contempt of the orders of the learned single judge, which they have not challenged.
October?
Yes.
No, not October.
Lords, 24/10/2024, November 2024. Lords, I just
Lords,
wanted
may
to
I
bring to your
come?
lordships notice. Lords, I'll take a, Lords, your lordships wanted to show the indulgence because they came before this honorable court and said,
And they have to undergo the
My lords, the
process of
appeal is filed by them, my
preparing the
lords.
electoral laws, voters list.
Lords, now this is the reason why I'm submitting, Lords. The reason why the learned single judge granted them a longer window than what was permissible was to comply with the requirements under law so that the elections could be conducted before July 2024. This was also keeping in mind the mandate under 28B of the Karnataka Cooperative Societies Act, which says that if an administrator is appointed, he has to conduct the elections before 6 months from the date on which he assumes office. Lordships may kindly have a look at 28B.
Then now what can be done? The
Lords,
time is-
now the issue is this. They did not challenge the order. They were required to comply with the orders of the learned single judge. This is not something which they can get us an order, my lords, in the writ appeal which I have filed. I'll withdraw my writ appeal and file a contempt instead. That's essentially where it stands. But if your lordship's direction is that keeping in view the orders of the learned single judge, which I have challenged, which your lordships said that in view of the impending elections of the Lok Sabha, they are given, my lords, a leverage so that they can give a schedule. If this is the manner in which they want to come, as a matter of fact, whatever they have now stated is a process which has already been undertaken. Lords, they are playing mockery with the democratic process. Kindly have a look at 28B for a moment, my lords. If they have scant respect for law, the courts has to implement it.
Then how can we set the clock back now?
28 minutes. The
How
mandate
can we-
is 24/7.
Now that time limit is already gone.
Time limit is not gone, 24/7 minutes. We are still in the month of May.
So they have started the process before.
Minutes, the starting of the process is commenced on 12/10/23 is the first notice, 23/12/23 is the second notice, 29/1/24 is the third notice. I will place, Milords, I will place these notices having been issued in terms of, Milords, the rules for the purpose of compliance, what they are now referring to. This has already been done. If this is the manner in which the government wants to hoodwink the court and the legal process, Milords, so be it.
The process is started. Mr.
Milords, this process has started in the month of January 2024. I'll place materials before your lordships that the process is commenced in October 2023 itself when the notices were issued.
So they have set out the timetable.
Lordships may kindly have a look at, Milords, the list which is now given. The notice to ineligible voters has been issued on 12/10/23, 23/12/23 and 29/1/24.
Where is that?
That's the reason why I said, this is a fact which is not brought before this honorable court. They are just making a statement, and this was the fact which was already placed before the learned single judge.
My lords may kindly see the impugned order, my lords. Why base, my lords, the order was passed on
place
22nd
it.
January 24.
If 29
And let
one-
them file a rejoinder, my lords, if they are unnecessarily making allegations against the state, let them place it on
It
record
is-
with the
He is saying
documents,
that
my
this
lords.
process of preparing of the list of voters started in January. Is it correct?
Lords, now I want to ask this question to myself. Your lordships did not intervene with the orders of the learned single judge. No interim order was granted. They were under a mandate to conduct the elections on or before 24/7/2024. Why they did not commence the process?
That we have granted indulgence.
Lords, your lordships have given the indulgence only to ensure that the expedited elections are not conducted, not to postpone it.
In the sense that in view of the impending Lok Sabha elections, they were permitted to have the time, and now they are coming out with the election.
Lords, that's the reason why I said, Lords, if this impending Lok Sabha elections is a reason for redoing the process, then I really fail to understand what is the mandate which is prescribed under law. Once the clock starts ticking, it will not stop. That is the mandate under the provisions of the Cooperative Societies Act.
Was any steps were taken earlier?
My lords, there were some steps taken earlier, my lords, but as per Rule 13D2A, they had not done the proper verification, my lords. Hence, a new schedule has been given after the various circulars which came to be issued, my lords. We are going to conduct elections. The grievance of the petitioners is addressed to my lords. That is their prayer. Do the elections, and we are doing the elections. And if they have any grievance with the
I
schedule
am requesting
provided,
your
my
lordships
lords.
to kindly have a look at 29B of the Karnataka Cooperative Societies Act. Whether the state can come and stand on its legs to say that they want to conduct the elections beyond 6 months. 28B.
When the term expires?
Lords,
July.
Lords, I'll just give your lordships the dates.
Madam,
The
term
term expired on 29/10/2023 and the administrator has been appointed from 30/10/2023.
Madam Counsel, the term expires when? July?
Please, my lords. Administrator is appointed on 27/10/23, my lords. The office bearers were elected on 14/12/2018. And the administrator is in charge since October 23, my lords.
Kindly have a look at 28B2.
October, my lords. From October, we are in charge. October, administrator is in charge.
May I just read?
Various
Lords?
litigations happened, my lords. It was the duty of the society to give the list, which they failed to do so in time.
Lords,
If my lord sees the
22nd
learned single
January,
judge's order-
22nd January is the date. Lords, I just wanted to say this. The board was superseded in the month of October itself. 27/10/2023, there was no board in existence. Once the board is not in existence, the state government is in complete control of this society. So what they have done is that they have issued the first notice on 23/12/2023. That is in compliance of Rule 13D2A. Then the second notice was issued on 29/1/2024 after the disposal of the orders of the writ petition by the learned single judge. Perhaps in due compliance of the orders passed by the learned single judge that the elections are required to be held by July 2024. Now, if an administrator is appointed in the month of July 2024, can he come before the court and say, I want to hold the elections in a period of beyond a period of 1 year? Kindly have a look at 28B3. The administrator who shall assume charge under subsection 5 of section 28A shall, as early as possible, but within a period of 6 months, arrange for the constitution of a new board of the society in accordance with the rules and bylaws, provided that the administrator so appointed shall not continue for a period beyond 3 months in respect of society of a credit cooperative structure. So far as credit structure is concerned, it's 3 months. So far as the other societies is concerned, at 6 months, he is not entitled to continue in the office. Lordships may now kindly have a look at 28A5. This is an appointment of an administrator under 28A5. Lordships may kindly have a look at 28A5. Lordships, if the new board is not constituted under 29A of the date of the expiry of the term of the board, or if the elections are not held within the time limit specified under 39A, registrar or any other officer whose jurisdiction the society is situated and who is authorized by the registrar shall be deemed to have assumed the charge as the administrator. He shall for all purposes function as the board of the management. Administrator shall be subject to control of the registrar. So the moment my term expired on 29/10/2023, they are deemed to have taken over as an administrator under 28A5. Nonetheless, there is an express order passed on 27/10/2023 that an appointment of administrator is made. Once the date of appointment of administrator is taken either as on 27/10/23 or on 29/10/2023, 6 months is the mandate within which they had to conduct the elections. That is a limited point with which I approach this honorable court in a writ appeal. Can I be relegated to a worse situation than what I was situated when I came before this honorable court in a writ appeal? In the writ appeal filed by me, no adverse orders can be passed against me in the writ appeal which I have filed.
The stage is indicated by the council as statutory.
Lord, that is the reason why I said 29/1/2024, the notice has already been issued.
Even the time limit
Please.
between the stages is also statutory, as per the
Please,
rules.
as per the statute and rules, we have framed this one.
Lords,
And my lords, the society, with
the
respect,
reason why the
with
6
due
months
respect
window
to the
is
learned
given.
senior council, my lords, the
But the-
society does not comply with a single rule. They do not give us the voters list
They have
in time,
superseded.
and they have come to the.
They have
we have-
superseded the board.
and
They
as
cannot have a
state,
grievance
my
against
lords,
the
we do
society
not have
now.
any.
Lords, is having superseded the board, they cannot have a grievance against the society. If we have not complied with the requirements and the rules and the elections are not conducted, we are bound to take the penalty under 28A5, where the board will be superseded with an administrative officer. That is a fiat accompli that's already happened. Now the next question is, after the administrator comes in charge, then the elections has to be conducted within 6 months. Why the 6 months period is prescribed is keeping in view whatever is now spelled out. I will produce materials to show that the notice was issued on 29/1/24. So 29/1/24, your lordships will have to fix the dates, which is now referred to as 16/5/2024. They have already issued the notice. There is no question of repetition of the same processes once again. Merely because they want to postpone the holding of the elections. Government has an interest to postpone the holding of the elections. Lordships may have this matter day after tomorrow, my lords. I am pleading urgency in the matter because the administrator's term as mandated under 28B is over. Administrator has to go out.
Honnapur.
Petition withdraw ಮಾಡ್ಕೊಳ್ಳಿ, contempt ಹಾಕಿ.
Please.
ನೀವು contempt ಹಾಕ್ಬಿಡಿ. ನಾವು ತಾನೇ ಹಾಕಿರೋದು. Contempt.
Please.
Ravi Shankar. Ravi Shankar. Day after tomorrow, my lords. Lordships, grateful for Lordship's indulgence in the matter. my lords.
Great.
This is number 17, appeal by government.
Number 1. Identification of the aggregate property was not, the registration of the state was rejected. Not the order of
Lord, I was the counsel representing the respondent before the learned single judge. I may kindly be permitted to undertake to file wakalat on behalf of respondent. Wakalat on behalf of respondent. I may be permitted to enter appearance on behalf of respondent.
This is number 18.
For the
Tarish
appellants in
NL.
this matter. The learned single judge has granted a relief which was not contemplated in the writ petition, which is totally beyond the subject matter of the writ petition. And then directed the beneficiary and KADB to pay compensation in respect of 34 square meters of land, which was a B Kharab land. If you may. 123.67 square meters of land was acquired for the purpose of a metro rail project, out of which 34 square meters was Kharab land. And on 12/4/2017, the petitioners received compensation by agreement under section 29(2) of the KAD Act towards an extent of 89.67 square meters, which excluded 34 square meters of Kharab land. Then later they filed this writ petition saying that apart from 123.67 square meters of land, the respondents are in occupation of more excess land to an extent of 325 square meters. Therefore, the writ petition substantially involved the question whether there is any excess land and whether any compensation has to be paid in respect of the excess land. My request is Honorable Court to kindly turn to page number 30. That is paragraph 2 of the pleadings in the writ petition, in which the petition specifically state that they are not claiming in the present writ petition regarding the portion acquired by the respondents. However, this 34 square meters of land, which is held to be Kharab land, it formed part of the acquired portion. However, the petitioners clearly state that they are not claiming regarding any portion of the acquired land. However, the learned single judge goes on to hold that this 34 square meters of land is not Kharab land and directs us to pay compensation.
I'm appealing for the fourth respondent.
It was not even subject matter of the writ petition. 34 square meters was not even the subject matter. Kindly see the prayer at page number 35. Page number 35. The prayer in the writ petition. At page number 35, bottom of page 35. Therefore, the petitioners respectfully pray that this honorable court be pleased to pass necessary orders and issue a writ of certiorari and set aside the letter bearing so and so as per Annexure J and direct the respondents to make necessary survey and inquiry and decide the excess land, more land than acquired as per notification occupied by them belonging to the petitioners and to pay necessary compensation to the extent of excess land occupied by them, or in the alternative, direct the respondents to vacate and deliver vacant possession. So, the petitioners have not sought for any relief with regard to the acquired portion of the land. 123.67 square meters was acquired. And then they specifically state in paragraph 2 that they are not concerned with the acquired portion of the land. They say that beyond 123. Yes, that is beyond the acquired portion of 123. They say that totally 325 square meters was acquired. So the inquiry that they are seeking for was in relation to a portion in excess of 123 square meters. So it did not pertain to the 123 square meters in which this Kharab land existed. The Kharab land was in respect of this 123.67 square meters itself. And the learned single judge also comes to the conclusion that there is no Kharab land which goes contrary to the survey sketch produced by the Additional Director of Land Records. On the contrary, the learned single judge had directed the ADLR to conduct a survey and produce a report. And the ADLR says that out of 123.67 square meters, instead of 34 square meters, he says 51.12 square meters is B Kharab. The sketch is found at page 124. The learned single judge comes to the conclusion that the Kaludari, which is about 34 square meters, is what we had said. And later ADLR survey says that it is 51 square meters.
I am also agreed. I am also appearing for fourth respondent. No, it's a B Karab land, they are not entitled. My lord, last yesterday also one matter. In so far, A Karab also ordered notice to the other side. I am also agreed. I also had appeal. Appearing for the land action officer, KADB. It's a B Karab land. No, they have received the compensation from
No,
us.
no,
I am for the land action officer, my lord, fourth respondent. Yes, my lord.
kindly see paragraph
B Karab
9
land
of
is
the
reserved under
order.
Rule 21. It's a government land, my lord. It is a reserved Karab, my lord. B Karab. They are not entitled to any
B
compensation for
Karab is
that extent.
government land which is reserved for a pathway.
Pathway.
And in paragraph
B
9
Karab.
of the order at page number 28, kindly see, accepting the said submission of the learned counsel, if it is found that first respondent BM Marshall has utilized more land than what was acquired and compensation has not been paid. No.
I have already appealed. Respondent number 4, my name is already shown. I already appeared.
Number 19, Mr. Ravi H.
May I please? Not recruitment notification was issued by the KPTCL on 1/2/2022 for the purpose of appointment of junior engineers, assistant engineers and assistant secretary. In the process of selection, there was an aptitude test which was conducted. We took the aptitude test also. Subsequent to that, they revised the key answers. So unilaterally, that affected our merit subsequently. So therefore, some of the engineers, assistant engineers, those who are applicants for the engineer, assistant engineers for selection, they challenged the same revision of the key answers before this honorable court. This honorable court, learned single judge, last may kindly see at page 184. Allowed the writ petitions on 22/8/2023, holding that the revision of answers is not correct in law. And direction was given to the concerned authorities to do according to the earlier notification and aptitude test scoring by the candidates. Under the same notifications, subsequent to this judgment, dated 22/8/2023, these appellants filed writ petition before the learned single judge. But under the impugned order now, the learned single judge has dismissed the writ petition on the ground that you have come to the court, after the judgment, you are a fence sitter and you did not come to the court earlier. And there is a delay of 8 months in coming to the court. Let these petitioners are the appellants before this honorable court, and the earlier petitioners in the earlier writ petition at Annex Sharemlet were applicants under the same notification. But here the question is not only the rights, the question of life is there. See, law which has been settled by this honorable court is to be applied. Therefore, my response submission is this matter request consideration, and this is and we were eligible before the revision of key answers. That has been done, let us say, unilaterally without any notice to anybody. That has taken away our rights. And learner single judge swallowed the Supreme Court judgment saying that there was a delay, therefore writ petition was dismissed. But that is a case where 9 years delay was there. Reasoning is at para 11 and 12. Para 12 and 13 of the single judge. Page 38, para 12. I have considered the arguments advanced from both the parties and have examined the issue put forth. The rationale in Natesh Nanjappa was that it was unfair for the candidates when key answers and merit lists are unilaterally revised. It is simply arbitrary to keep revising the same without letting the recruitment process attain finality. However, in this case, it is impossible to ignore the petitioner's delay of 8 months in approaching this court. Given the circumstance, it would be apt to answer the judgment rendered by the Apex Court in Arvind Kumar Srinivas and extended fiduciary, self-explanatory. But that is a case where 9 years delay was there. That is not the case so far as our case is concerned. No, blood, you lost my kindly similar. In the instant case, what has happened is this. Under the same notification, earlier applicants before this honorable court. This honorable court considered saying that revision. But I have sought for interim order also left. July. Great.
Number 20, Mr. Mohammed Sahni.
Responding.
They appear for the issue.
It's 49 also, my lords, is a state writ petition. Please.
Yes.
Please.
Yes, it's
Please,
against.
my lords. It's an against an
order,
interim order.
Staying the order of suspension of the first respondent and placing the appellant in charge of the post of director.
That's one
So the
submission.
brief facts are these.
Serial number 49, my lords, is a state writ petition, state writ appeal challenging the same order. my lords. It may be taken up together. my lords. Serial number 49 is a state writ appeal challenging the same order along with 20 my lords. Both can be taken up together as a request.
Bow down to that. May I request the court to kindly turn to the order of suspension that.
Lords, the state has, lords, the matter pertains to, my lords, the post of director of Kidwa Institute of Memorial Oncology, which is a premier cancer institute. Now, my lords, the director, there were some allegations, my lords, with regard to mismanagement of the institute. The 3-man committee was constituted, my lords, and the 3-man committee has given a report, my lords, with regard to several irregularities, my lords, that has been committed by the director of the institute. Thereafter, my lords, action was taken. In contemplation of disciplinary proceedings, my lords, we had suspended. Now, my lords, learned single judge, my lords, has stayed the suspension order. Please. Lords, we are aggrieved by it, my lords, because the state, it is a state institute, my lords.
May I please? The order of suspension is at page 111. In one of the cases that was brought up before this court, before Honorable Mr. Justice Ramajoy, as he then was, it was a trap case and the trap was laid during the order of probation. So the learned judge asked, we should have waited till the probationary period was. Now here is a case, kindly turn to the allegations at page 114. Even before he becomes a director, he issues the order. I just read out. It is a 3-member committee which was constituted to go into the allegations against the director. And the 3-man committee has unanimously found the following irregularities. 1. Issuing the work order in respect of PET-CT scan service prior to taking in charge of the director. So even before he became a director, he issued work orders in favor of the company to supply the PET-CT scan service. 2. Not taking any action as director of institute, even though tender conditions have been violated by the institute providing the PET-CT scan service and violation of the Karnataka Transparency in Public Procurement Act of 1999. 3. The rules in KTPP Act have been violated in the tenders called for the collection of medicine and chemicals necessary for bone marrow transplant BMT unit. 4. The rules of KTPP have been violated in the tenders called for management of purchase and stock of management of medicines necessary for the institute. 5. Financial loss has been caused to the institute without properly managing the financial resources and its management of the institute. So these are the 5 main allegations. There are other allegations also which have been found to be true by the committee. Now this has been accepted by the government. The aspects proposed in the inquiry report concern term of office of Dr. Lokesh, who was taken charge as director, has been proved. There are possibilities that if Dr. Lokesh is continued as director of the said institute, he might destroy the evidences and documents. Therefore, it has been decided to suspend Dr. Lokesh, Director, Kidbai Memorial Institute of Oncology, by reserving departmental inquiry as per Rule 10(3), and it has been ordered as well. So accordingly, he is placed on. So this is a premier institute of oncology in the state. It is one of the well-known, highly reputed cancer research institute. Now in that institute, most of the patients who come for service are the poorest of the poor and who are terminally ill. So in respect of such patients, the treatment to be given has been completely destroyed by the acts of omissions and commissions which the committee has noticed. And my instructions are the irregularities are to a tune of over 50 crores in the allegations that are committed. So he is placed under suspension. Now that is stayed on the ground. Number 1, there is no transparency in issuing the order. Number 2, there is no specificity in issuing the order. My very respectful submissions are Rule 10(3) does not mandate any such things. There is no need for issuing a notice before an order of suspension is made, and accordingly suspension order has been made. May I request the court to kindly turn to Rule 10(3). It does not contemplate. In fact, suspension is an order to prevent any further damage being done. Here he is kept out of office to prevent him from handling the papers and the files relating to the cases which came up before the committee. Now that has been stated by the learned single judge. On the ground, may I request the court to kindly permit me to show from the order under appeal at page 20. If that liberty is given, we'll move the learned single judge. Yes.
Lord, sir. In fact, from the date the impugned order is passed, in the meantime, Lords, an administrator also was appointed in the institute. Now we will complete the pleadings, my Lords, immediately before the learned single judge. At least. Yes, my Lords.
So it may be only one request. In the meanwhile, because the magnitude of the problem was such, it was noticed that the director had bungled at every step. An administrator has been appointed. It is a society. Yeah, an administrator has been appointed. It is not under challenge. Let the administrator run the show. We'll move the learned single judge. He cannot get an interim order like this because this
Administrator was there even earlier. There was no difficulty about it. Administrator is there, director is there. Both. Correct, correct, absolutely.
Lords.
The order of administrator is not under challenge. Yes, we will. I agree. I agree. We have the liberty to move the learned single. Yes, that liberty may be given. We'll approach the.
Only one observation, my Lords, for expeditious disposal. One observation, my Lords, so that we can request the single judge for expeditious disposal. Because now administrator also can be maximum 6 months, my Lords. And again,
on the last date of hearing, an order is made.
Lords, may I just bring one fact? 49, there was an order on the last date of hearing. Lords, I appear for the state. For contesting petitioner, it is. Lords, I'm Ruben Jacob, additional AG. Lords. Please, my Lords. Please, in charge director.
Please. It is a consequential order on this suspension. So if suspension order says. He's actually an expert here.
Was hurt. Age was hurt.
Yes. Let's speak.
No date has been given, Manoj. After vacation. Manoj,
Thursday.
maybe.
Thursday. This Thursday.
On fifth.
I may be given liberty to. Please, I may be permitted to. Yes. Yes. I have to apply for vacating the order because it is. Yes. Great. Please.
Grateful.
In serial number 49, on the previous date of hearing, an interim order was made that the first respondent shall not interfere with the
No,
administration.
no. Nothing of that kind.
Will cooperate.
Huh? It's all, whatever is there.
That may be.
There was a direction that first respondent is directed to cooperate with the administrator.
Cooperate, my lord.
Although that.
We have never.
Please.
In the writ appeal, there is no interim order passed, my lord.
It's an interim observation direction.
Please.
We'll cooperate, my lord, with the administrator in the smooth functioning. That's all that it
Anyway,
says.
He's not doing it.
interfere. Even otherwise, he cannot interfere.
My lord, I did
How
not want to
cannot
say this.
interfere?
This gentleman, my lord, came up for
It
the,
is not under challenge.
this gentleman.
That order cannot be whittled down in the garb of
This is the writ.
exercising his rights under the interim order.
That's all. My lord, we have never. Correct. Absolutely, my lord. Great.
Paragraph 14, my lord. Page 116. The labor court, my lord, has considered this aspect of the matter. Lord, they have also produced the scheme. Annexure B is the scheme, you know. Page 46. Page 46, my lord. Introduction of revised voluntary retirement scheme. Voluntary scheme 2000 covering the executives and non-executives is introduced with immediate effect. The details of the schemes are furnished at annexure. Employees desire of availing the voluntary retirement under the scheme may submit their application in the prescribed format, along with duly filled in the letter of consent to deposit the amount in sale public deposit scheme through their sanctioned dates on or before 31st. This period, my lord, went on extending from time to time. This was the scheme. But ultimately, my lord, this application was filed in 2000. My submission is this, my lord. Here is a case when a voluntary retirement application was dated, my lord, on 14/7/2001. Well, I also produced the consent letter. That is also a mandate under the scheme. My lord, consent letter also is there at annexure C, under which he has made it clear. My lord, please accept it with prospective date is shown as 31/8/2001. It is a prospective, my lord, even that is one of the ground which what you have urged even before the labor court. Then, my lord, annexure F is the withdrawal of the voluntary retirement application. VRS was withdrawn by me on 57. This was the letter sent.
21.
Lord, I will read one document, my lord, if still your lordship feels, my lord. That's how, my lord, something is there in this that has not been examined by even by the labor court, by the learned single judge, with great respect, my lord. Your lordship, I kindly say, my lord, withdrawal is, your lordship is, the position is, legal position is well settled. I am entitled to withdraw the VRS, my lord, before acceptance. It is a settled position of law. Now, my lord, I filed an application and I've sent application for withdrawal on 24, my lord, on 24/7. My lord, this was sent by three, one is by register post, one by, my lord, certificate of posting. My lord, this was subsequent, your lordship, I kindly see, I have sent the register within 200 meters from within the premises only. Because they refused, because something was there, it has not brought out before the labor court. But annexure K, my lord, your lordship, I kindly see, will pay 69 for the time. Annexure K, my lord. Annexure K. I have given because, my lord, they say that we are in the receipt. Why there was a delay in communicating these two, serving these two letters, delivery of these two letters. Now, your lordship, may kindly see page 69. We are in the receipt of your above cited letter, page 69. This was by the superintendent of post office, customs care center. Now, we are in the receipt of the above cited letter. Enquiry may reveal that the below mentioned article was issued to the postman for delivery on 27/7/2001. And he has issued the intimation slip on the same day. Address is not available on the day. On 1/8/2000, the article was delivered to the authorized person, C.R. Srinivas, on the basis of the authority letter given to the addressee of the article. The copy of the authority letter is enclosed herewith. Yes, my lord. Because now annexure L, my lord, this order was passed on 27. 27/7, my lord, saying the next document, your lordship, may kindly see page 71. Acceptance of VRS with effect from 31/7/2001. That is much earlier to that. All these communications were very much there. But the community, that's what I have also read, my lord, I cited two judgment. My lord, because that is the reason I said that, my lord, the post office well within the premises of, my lord, that I have also communicated, my lord, the communications are acceptance, my lord. That is more, acceptance is for receipt of the letter is more important. Now, my submission is, my lord, I will place some judgments on. I will place the judgments on that. One week time, my lord. Next week, my lord. May I request? May I request your lordship, kindly have it on 6th, my lord. 6th. Please.
For complaints in contempt matters, case number 22, Mr. Partha TP.
Yes, I am prepared for the respondent and for the petitioners. The interim order, we have filed a writ appeal that is connected. The contempt is non-compliance of the interim order, over which we have filed an appeal. That is also listed before the lordships today. What has happened in this case is, if I may make a submission, the orders of termination have been stayed. Supreme Court says when there are not, termination cannot be stayed as an interim relief. Two judgments of Supreme Court. I have circulated the judgments also. My lord, these were all employees who were appointed on ad hoc basis by the branches. So there was a dispute raised by the that is, when our court said, continue them in service. They had already been terminated. Therefore, question of continuing them would not arise.
My lord, I can make my submission. Will complete it.
1 minute. Page 31, my lord. So, contempt only.
My writ petition was filed, my lord. 29th of September. Order is given. Page number first one. Page number 1. Daily status.
Page 15.
That's 15.
Interim order. Page 15. You hold it.
My lord, I will read it. Had this learned counsel
Contempt page number.
contempt ಅದು page number ಅಲ್ಲಿ ಬರ್ತಾ ಇಲ್ಲ.
15
Stitch ಮಾಡಿದೀನಿ.
Page 15 of your petition.
Page 15.
ಹೌದು.
Page 15. He is giving interim order only. Interim order only.
For which we filed an appeal.
Interim order only. Interim order only. Had this learned counsel but there is a case law. But sufficient.
We filed an
grounds-
appeal against that order. We filed an appeal against this order. That is listed below.
See, the problem is, my lord, these employees, they are not getting their salary. They are not allowed into the premises also. Through watchmen, they have sent them out. And this is going on happening since 4 months. And Supreme Court, there is a Bombay High Court stay order also. Bombay, yes.
Bombay High Court was succeeded.
Bombay High Court.
Bombay division bench was succeeded. And Madhya Pradesh also was succeeded.
Yes, sir.
Upholding our policy.
No, Bombay High Court stay order is there.
Bombay High Court duly means notes.
Can I read this, my lord, at least? Bombay High Court has given, Supreme Court has also given the stay.
Supreme Court has not given a stay, sir, please.
I will give the copy. Supreme Court has given, in the case of the Kolhapur, this 965 union has filed. For that they have given.
March, sir.
Interim only, everybody.
17th March, sir.
ಯಾವುದು?
Supreme
August 24 ಹಾಕಿ till the next date of soliciting operation improved order shall be remain stayed. 24th March ಹಾಕಿದ್ದಾರೆ. I give my submission at least, my lord. My submission with regard to the contempt. Here in this letter, whatever he has written, the branch manager. Then writ appeal may be disposed in favor of this one.
No, writ appeal I have filed.
To the single judge. No, no. This single judge. It may be direction may be given. No, we are not withdrawing. No. It can be referred back to the single.
Kirloskar judgment delay. ಮಂತ್ರಾಲಯ ಹೇಳ್ರಿ. Look, my writ appeal, my appeal is against this interim order. That's it. My lord, the termination has already taken place in state. Supreme Court says it cannot be done. Your lordship, kindly have a look at these two judgments that I have produced before the court.
Petition.
Kindly,
Nothing, my lord.
kindly see page 114 of the appeal.
28
They
August.
rejoinder before the Honorable Single Judge. 114 of the writ appeal. Where they say they were terminated when the matter was pending at Apex Court, in this Honorable Court, Bombay High Court, various courts. When the services have been already terminated, the question of granting an interim order in a writ petition to continue them in service would be contrary to the judgment of the Supreme Court. So Lordship, kindly have a look at these two judgments I have produced, my lord. Lordship. I had filed an objection to their application for vacation of stay. There was no stay. We filed objections to this. It was heard and my order was passed. Your lordship may permit us to file an application for vacating stay before the Single Judge. Liberty to move the Honorable Single Judge to vacating stay. my lord. Much obliged.
Number 23.
I appear for the complainant in this case.
The accused,
Lord, there is an order on the last occasion in this matter saying that this is a clear case of contempt. The court has passed a direction that we should be given our option under the old pension scheme and our past services should be taken into consideration and pay should be fixed accordingly. Board says we will not comply with this order. They passed a resolution.
May I make a mention? But the challenge is being done by this before the Supreme Court, my lord. It's not been listed. Yes.
Lord, this order is
Yes,
passed
my
in
lord.
May
Division bench.
2022.
Lord. My lord, division bench is at 14, my lord. Page 14, my lord. This has been challenged, my lord. SLP has been filed, my lord. Yes, yes, my lord. Diary number has been issued, my lord. 49095 of 2023.
Let kindly see the previous on the last occasion dates order on 18/4. This is nearly almost 1.5 to 2 years are over now. They are still in the process of filing it. And the board passes a resolution saying that the order cannot be implemented. A clear case of contempt I have produced in the additional documents. The proposal to comply with the order is rejected by the board. The Lordship may kindly take the additional documents which I have filed. At page 11 of the additional documents. The approval is requested by the board to comply with the order. Approval request at page 11. Not here in the court.
On 18/4/24. So quote the order. Safer. Lord, when the contempt petition comes up for after quoting, when the contempt petition comes up for consideration today, what's your good name? Learned
Srinivas
advocate?
BS. Srinivas BS.
Srinivas
BS.
PH for the respondent. Again prayed for time. Putting forth the same ground that the SLP is filed against the order under contempt. And that the diary number is available.
Yes.
He stated that the appeal is likely to be listed when?
As soon as the vacation, my lord, I will.
As soon as vacation. And that the respondent shall take steps to get the appeal listed. Full stop. We have not, the court has noticed the earlier order dated 18/4/24. However, since the SLP is filed before the Supreme Court, the court permits the respondent to seek appropriate orders from the Honorable Supreme Court, expectedly moving the Supreme Court at the earliest. Full stop. It is provided that unless the appropriate orders are obtained in the SLP on or before 31st July, the respondent shall comply with the directions in the order brought under contempt. Right? To be subject to the contempt. Put upon, we'll list it on 22nd July.
Much obliged.
Know the progress from.
Yes, I will. Much obliged.
Number 24, Muralian.
Hearing for the statement.
Writ of PIL, my lord. Seeking a direction to consider my representation at Annexure A.
There's a
Delay.
recalling
Recalling application,
application
Lord,
and a
this-
delay for that application.
This Honorable Court had, my lord.
Where is that? It's 2 of 23 for recalling.
2 of 23 and 3 of 23.
Delay in I. So we'll have both.
Please, my lord.
Delay is what? Delay?
181 days.
181
my lord.
days.
181 days.
181. So IA3 is for delay.
Please.
IA2 is for delay, IA3 is for recalling the order.
3 for recalling.
Please.
So IA number 2 of 23 with IA number 3 of 23. Heard learned advocate Mr. So-and-so the applicant. Learned additional government advocate Ms. Pratima.
Shweta Krishna.
Shweta. Full name.
Shweta Krishnappa, my lord.
Krishnappa for the respondent in both the applications.
1 to 4.
Krishnappa for respondent state in both the applications. Then subtitled order in IA number 2 of 23. The present interim application is filed seeking to condone the delay of 181 days, which has taken place in filing the restoration application. It appears that writ petition came to be dismissed on account of non-removal of office objections. When the restoration application was filed, the delay occurred. Full stop. From the averments made in the application paragraph, petition cause is made out to condone the delay of 181. Delay is condoned, application is allowed. Order IA number 3 of 3 of 24. 25. This application is filed seeking to restore the writ petition which was dismissed on account of non-remove of office objections on 11/11/22. It is to be noted that as per the above order, delay in filing the present application has already been found out. The learned advocate for the applicant submits that the office objections would not be removed within the time granted on account of bona fide inadvertence. Most of, even otherwise, it is right that the litigant should be allowed to contest his case on merits rather than being thrown out on the technical ground. To stop considering the above, considering the submission of learned and further considering the submission of learned for the applicant that the office objection shall be removed within the time
Already removed, my lord?
granted by the court, the application deserves to be allowed. Writ petition number so and so 9532 of 22 shall stand restored to its original file along with the subsisting orders, if any. On condition, however, that whatever of office objections are left out from being removed, shall now be removed within period of 10 days.
It's already removed, madam. Office may verify it.
Full stop. At this stage, learned advocate for the applicant stated that all the office objections are removed. Full stop. The office shall verify the same. Full stop. If the office objections are removed, the petition shall be restored, shall stand restored automatically.
Yes.
Application is allowed recorded.
Number 25. In for the appellant, your lordship. We have filed the I number 1 of 2024.
Appeal only for cost. Appeal against cost only 50,000. Appeal is filed against the cost part only.
No, your lordship, we are bringing the LRs to the record. Bringing the LRs of an appellant number 11. You filed an
Heirs application, sir. But you are pressing the appeal for entirely or for cost only? We'll see, we'll grant this then, the heirs application. What about the main appeal? Anyway, you are not ready. So this is an application for heirs. Can be granted?
For Respondent number 2.
It can be granted.
Appeal is, this appeal is regarding to the regularization of the.
Today, council is arguing only the application for bringing heirs on the record. Of which deceased?
Appellant number 11.
Appellant number?
11.
7.
11.
11. So it can be granted?
No.
Granted, allowed. Not dictate letter. Yes.
Meanwhile, we'll file the amended cost title. We'll file the amended cost title in meantime.
Pardon?
We'll file the amended cost title meantime.
We'll provide in the order. Yes. So this application is allowed. (26).
For 26.
Here is the one more.
The appellant has questioned the appellant now has retired from service on 31,
But you are
23.
challenging charge sheet
Yes, my lord.
on the ground that
On the ground of competency and not the vagueness.
After you go before the inquiry officer and tell. the
Competency
inquiry
is
officer,
concerned, nobody, but court has to say something about it. Not,
We are not preponing the or preempting the inquiry process.
not, I'm not on the merit.
Single judge said the.
I'm not,
charges-
I'm not on the merit. Lord. It's a clear case, Lord, where this appellant is victimized, scapegoat.
What are the charges?
Lord, kindly see the charge, Lord. Strange charge. Because of the reason the other colleague, my Lord will find the charge memo. Very silly charges, not page 95. The charge is that there are 5 allegations, 6 allegations. The charge number 1 pertaining to what? The appellant has what? Committed misconduct in conducting what? Fellowship examination.
The learned single judge said that, in my view, the charges that could be seen from the extracted portion above are not vague. So who are we to say that they are vague?
But question, there are 2 questions raised. Number 1 is competency. Charge issued by the Lord, the vice chairman of the council. And you see,
Sanjay Gandhi Institute of
yes,
Trauma and
he is
Orthopedics.
not the competent person to issue charge memo.
In charge director.
They are governed by
Translated.
Lord, recruitment rules. My Lord will find page 176. The disciplinary proceedings are regulated by the recruitment rules. Who is the disciplinary authority for the post of director? I produced the entire the recruitment rules approved by the government. Page 196 is typed copy, my Lord. And you see, who is the authority to institute inquiry against the post director? Page 196. The appropriate disciplinary and appellate authority for the various posts. Group A, Class A, Director, Appointing Authority, Governing Council, Disciplinary and Controlling Authority, Governing Council. The charge memo is issued by the, and you see, my Lord, the charge memo issued by the vice chairman of the Governing Council. Page 97. Annexure page 93, charge memo.
Yes. Yes.
And you see, who is the authority? Who has issued charge memo? Vice chairman has issued the charge memo. The learned single judge, my Lord, without examining this question, though I have raised, and you see, my Lord,
What is the challenge in the main petition?
charge memo.
Same charges.
Charge memo. On the ground of competency.
Just, my lord,
On the ground of
my
competency.
learned senior's argument has been answered by the learned single judge from paragraphs 2 to 4, my lord.
No, I read that. I
Page
read
36 and page 37.
page 36, my Lord. I read, my Lord. There's no difficulty at all.
Paragraph of the order of the learned single judge.
But can you see, my Lord? It is a very short order. I read it, my Lord, that also. It is contained, a charge sheet is issued by an incompetent authority. Charges against the petitioner are vague. It is also contained at C&R rules. It is the governing council, which is the appointing authority, whereas a charge sheet has been issued by the vice chairman of the governing council. Therefore, it is without jurisdiction. Reliance is placed tabular column 132, amended. However, whether amended tabular column is a part of C&R rules, whether it has obtained the approval of the government is not forthcoming. As much as amended tabular column does not contain the signature of the authority of the government. But without issuing this notice, whether this document produced by me is a juvenile or not, but Learned concludes that there is no such recruitment rules at all. And if you know page 176, that is for recruitment rules. 176, the entire recruitment rules is produced, which is approved by the government. Because under the bylaw, under the rules and regulation, it must be approved by the government. And it's not that also. Page 177. I produced the xerox copy of the entire recruitment rules, which is approved by the government. The learned single doubts this. To doubt also or not, it is a case for issue notice and ascertain it, whether it is or such a recruitment is
Lord,
existing or.
This is writ appeal number 95 of 24. Lord learned senior advocate, so and so.
One more question is the charge memo is issued. One of the charge memo is issued.
So this is premature. You take all contentions, including vagueness, incompetency, illegality before the. We keep
Unless
it open.
competency has to be decided by this court.
Whatever
But it is a disciplinary, one charge memo is issued, they cannot decide it.
Whatever objection you want to take in relation to
They
charge
cannot
sheet,
decide. They
inquiry.
cannot decide. That question cannot be decided by disciplinary authority.
Why?
But then they issued it. Vice chairman of the council has issued the charge memo without looking into the recruitment rules. Where I have to send to the court only, but nobody else can decide it. But that's the difficulty which I face.
Writ appeal number 95 of 24. Heard learned advocate so and so, assisted by learned advocate so and so for the appellant, and learned additional government advocate Nilofer Akbar for the respondent. Referred under section 4 of the Karnataka High Court Act 1961. The present writ appeal is directed against judgment and order dated 19th December 23 of learned single judge, whereby learned single judge dismissed the petition of the appellant petitioner. Full stop. The writ petition came to be filed by the petitioner seeking to challenge the charge sheet issued to him. Full stop. The charge sheet was sought to be assailed on two main grounds. Firstly, that the same was issued by the authority who was incompetent to issue the same. The second ground was that the charges leveled against the petitioner were vague to be countenanced. Full stop. Learned single judge paragraph dealt with both the aspects of the controversy raised by the petitioner to observe about the competency to issue the charge sheet, as under in paragraph 4 of the order, to negative the said contention. Paragraph 4. Full stop. The other contentions were other contention that the charges were vague was also closely examined by learned single judge by noticing in detail the charges to come to conclusion that the charges laid against the petitioner could not be said to be vague. It was observed that the contentions of the petitioner were essentially a defense which could be raised by him. Full stop. In any view, this court has gone through the charges and the court is inclined to concur with to endorse to the view of the learned single judge, and the court endorses to the view of the learned single judge the charges could not be said to be vague. Full stop. In any view, the writ petition which challenged the charge memo was premature to be liable to be entertained. Full stop. It is further observed that the petitioner could always raise all the objections in his defense in the inquiry proceedings. Full stop. No error could be booked, paragraph, in the order of learned single judge dismissing the writ petition. The present appeal stands meritless. The same is dismissed.
My lord, the observation may be made. If the appellant raises such objection before the disciplinary authority, they may be, my lord, at least examined and pass.
We have given liberty to.
Yes,
raise
my
all
lord. My lord may at least direct them to, if he raises, if
All
so far he has not
objections-
filed any objection.
Appellant has liberty to raise after that sentence. All objections which may be raised in accordance with law by the petitioner in the inquiry proceeding shall be considered by the inquiry officer on their own merits.
And disciplinary authority, and as well as disciplinary authority, because inquiry officer is subordinate to disciplinary. My lord, no, he cannot do anything. He says, I am appointed to inquire into his charges. I cannot do anything. You have to approach the disciplinary authority. My lord may observe that disciplinary authority may. Otherwise, my lord, I left no remedy at all.
You are at the stage of inquiry. Where is the question of disciplinary authority? Inquiry is yet to commence.
If I raise that question of competency, but again the inquiry officer.
You said all questions, competency, incompetency, irrelevant arguments, yes.
my lords. So permission seeking for adjournment, my lord. Serial number 31, my lord.
31.
Appellants.
Yes.
Senior inconvenience is there, my lord. Senior inconvenience is there, my lord. Kindly adjourn matter for 1 week, my lord.
Time,
Yes, my lord. For 1 week.
July, 11th July.
Right.
Lying, really.
Number 63 for withdrawal.
I appeal for the complainant. I appeal for the complainant. Plus, I have filed a memo for withdrawal. They have issued an endorsement dated 3/11/2023. That with liberty to challenge that endorsement, the complaint could be closed. I have filed a memo on 17/11/2023.
In view of the memo dated 16/11/2003, filed by learned advocate for the complainant, seeking to withdraw the present contempt proceedings, stating inter alia that the representation as directed by learned single judge has been decided that the complaint the present things are disposed of as withdrawn. It was requested that the liberty may be reserved for the complainant to challenge the endorsement of the order dated 3/11/23, which is passed in response to the representation. It is open for the complainant to challenge from if agreed from the said endorsement in accordance with on merits. And by instituting independent process. This is the contempt disposed.
Much obliged.
Number 64, Mr. Sanjeev BL.
Seems, my lord, the complainant is present. He
Lord,
says
we
the
have-
interest is not being paid, my lord, the learned government
Client's affidavit wherein substantial order has been complied with. So far as the interest is concerned, there's some ambiguity in the order from when it has to be paid. Lords, we are filing review on that. Government order has been issued to file a review to decide the order. We were given, my lords, 2 months' time to comply with the order. However, it has taken 11 months to comply the order. It was a delay of 9 months.
So what remains? Interest.
No, the interest is not being complied, my lord. Otherwise, everything is compliant.
The direction of learned single is with interest. With interest.
The first payment, my lord, is only on 8/4/2024.
Sorry, delay, how much delay beyond 2 months?
Lord, 8/8/2022 is the order, my lord. 2 months from 8/8/2022 would come 8/10/2022. And my lord, if at all, if you consider that copy was received to us on 20th/9/2022, giving out 1 month, my lord. The payment has been done on 8/4/2024. 6, 8, 9 months.
Thus, the order is dated 11/7/2023, which is produced at R2, my lords, page 7. On page 11, your lordship will get the date 11/7/2023.
We approach them for interest. We are not. We'll close substantial compliance. We'll revert it with, reach out to you to make a representation for interest.
And then I'll again have to file a writ petition for this, my lord, if they don't pay.
Delay of 9 months is 9 months.
Yes, my lord. 22, my lord, 8th August
You
2000.
can't change the directions of the contempt.
My lord, not even, I'm sorry, my lord, it's not even 9 months. 8th August 2022.
Whatever
the division.
what is there, you have to comply with.
Lords, we will file a review, my lords, there's a government order to issue only with respect to the interest part, because there is ambiguity in the order from when the interest has to be paid, my lords.
After 2 months, whatever delay occurs after 2 months, the interest will become due to be paid and recovered from the pockets of the
The order says in respect of the
officials.
monetary benefits.
That is the direction.
Please.
We are not, we can't change the direction, nor modify, nor relax.
So we, lordship may guide us 6 weeks' time to file a review, my lords. And take note of the substantial compliance.
What you are doing till now? You could have filed it. So why there is a delay of 9 months? You explained it?
No. Yes, ma'am. To some extent we have explained paragraph 5 on in our affidavit.
5 of the compliance.
Please, compliance.
But the only thing that we can't modify it in contempt is
We obtained a government order to file a review only in respect of the interest part, my lords. Lordship may kindly note the substantial compliance and the outcome of the review petition.
Review, my lord, still now it is not fine. The division bench order, my lord, is on 8th August 2022. My lord can produce the annexure R3, my lord. R3 is on 5/12/2023. Sorry, it is more than 9 months, my lord. And the payment, my lord, is at 8/4/2024.
the direction of learned single judge was to regularize the services of the respondent original petitioner and settle the entire pension and other benefits, retirement benefits, other benefits, other related benefits to be paid within 2 months. Full stop. It is not disputed that there is no dispute that the directions are complied with. Full stop. The controversy, the rest of the direction contained that if the pension is not settled and paid within 2 months, or it will carry interest at the rate of 8%, pension and other benefits. If not settled and paid within 2 months, they will carry interest at the rate of 8% to be recovered from the hearing officials. Full stop. It was urged on behalf of the contempt petitioner that the payment of pension was almost after 9 months. Therefore, the petitioner is entitled to paid interest as directed. Full stop. At this stage, learned additional government advocate, Miss
Pramodini Kishan.
Pramodini Kishan. 6 times. Full stop. The court has noted the substantial compliance of the order. Full stop. For the rest of the part, as prayed for, time is granted to the respondent.
May I make a mention?
Full stop. 10 to 10th July. Whatever you want to do it.
Lord, may I
We
make a
can't
mention?
say.
9 months, I'm sorry, my lord, my apology. It is more than 9 months, my lord.
Course of the rest of the aspects shall be considered on the next date.
9 months, it's come up in the order, my lord. I'm sorry. It's more than 9 months, my lord. I'm sorry.
Yes, we are not closing the things.
Yes.
Nor we observed anything about permitting them to go.
Lord, that
Whether they
states
can
that
go
I
at
have
this-
stated, I have stated
whether
9
they
months.
can go at this stage after compliance.
My lord, I'm
We
sorry,
don't-
my lord. It is stated that I've stated 9 months.
So they will take their decision as per their own wisdom. They can also pay the interest. We do not. You take your own decision.
Number 65, Mr. Ravi Shankar, is it?
Siddlam.
Appearing
Or
for
learned
the state
advocate, Mr. You are Mr.
I am Ravi Shankar.
Ravi Shankar SS for the petitioner. Learned additional government advocate Swetha
Krishnappa, my lord.
Krishnappa for the respondent state.
I appear for respondent
And
number 1.
learned advocate Mr.
Kumar MN.
Kumar MN for
Respondent number 1 ASN.
respondent 1 who appeared upon service of copy of the petition in advance. Full stop. The petitioner happens to be you are what? Association or
Organization, my lord. They are an
Organize-
organization.
Organization.
yes. Championing the cause of
who has
Hindu.
filed this petition in the nature of public interest petition. The case is that the structure of Jamia Masjid situated at
My lord, if I may just.
Srirangapattam.
If I may just submit,
Srirangapatna.
I just want to make one submission in this case, my lord. The petitioners herein have come before your lordship under a public interest litigation, seeking for a demolition of an existing Jamia Masjid, stating that there was a Swami Anjanaya temple. And they have also put forth annexure B1 and B2, which is actually, if your lordship sees, annexure B1 at page 60, my lord, is the Archeological Survey of Mysore, done in the year 1912, which speaks about how this Jamia Masjid was there since then. So the entire case has no premise to stand on, because basically it is protected under the Archaeological Act, because it's more than 100 odd years. So I don't,
there seems to be no premise for having this public interest litigation.
We are not concluding it.
Please.
File your.
But I have not sought
What did you?
demolition of the structure, nowhere.
They have,
No, no.
Please go through the.
That is, my lord,
Which
I have
was
never sought.
constructed by
you have,
Tipu Sultan, was on the site of Mudala, MWO, DALF, Bagilu, BAJLU, Ajanea, Anjanea, ANJ, NUI temple. Full stop. It is played in the context of the said basic premise is to direct. Number one, the Archeological Survey of India and its authorities to conduct archaeological study, survey, excavation, and undertake the excavation at the disputed place. Full stop. According to the petitioner, the site is of national importance and has to govern under the Ancient Monuments and Archaeological Sites and Remains Act 1958. In support of the claim paragraph, that the will not write masjid. Masjid will not, will say the religious place existing at that in earlier was built on the land of so and so temple. Full stop. In support of the case that the present religious place was built on the land of temple, the petitioner has produced the annual report of the year 1995, annual report of the Archaeological Survey of Mysore, 1912, volume 5, in which it is inter alia mentioned that the present structure was constructed with Tipu Sultan on the top of an Anjanea temple after filling up the letters LATE, LATTERS, RS, ground floor. Be as it may, view the act, full stop. Archaeological. Learned submits that in light of the such historical facts revealed, it is the duty of the archaeological authority to activate themselves under the provisions of the Ancient Monuments and Archaeological Sites and Remains Act 1958. He relied on several provisions of the Act. Full stop. Without entering into merits and without expressing anything on merits, at this stage, there shall be notice to the respondents. Returnable on. July 11th. Respondent may file their account.
Actually, page 62 and 64.
You know nothing can be.
Acha.
Difficult, very difficult in dead petition. But they have produced something, therefore we have.
The report itself says that during.
Mr.
the-
Counsel, this is also under the, it is a protected monument. Present structure.
Yes.
So what, how can you change it in a writ jurisdiction? It is very difficult.
And it's noted.
Whenever there is a
in-
protected monument, entire,
Correct.
it is centrally protected monument, according to 1951 notification. If there is any dispute with regard to that, only the ASI can enter upon and conduct survey or file the report. And that, others cannot enter upon the.
We are fully aware.
Acha, sir.
Orders. Non-filing in contempt matters, seal number 27. Ashwin Kumar MS.
Wait for some time to comply the orders.
Thank
Yes, ma'am.
When do you want?
About 2 weeks, my lord.
2 weeks.
Much or less.
Seal number 28. Dinar.
Worship, as against the order of the learned single judge, they have not complied. BDA is to issue the
Conveyance.
no objection for Khata. They have not yet complied. Your Lordship.
Lords, may I submit, my lords? There is a writ appeal that is pending, my lords. Writ appeal that is pending, it may be tagged along, my lords.
Appeal is pending.
Yes, my lords.
They
Writ
filed the
appeal.
appeal after we filed the contempt. It has been conveniently lying without complying office
When it is
objections.
coming?
My lords, 1192 of 23, my lords, I will get the matter
Listed
posted. my
with
lords.
writ appeal number 1192 of 1990
23, my lords, 2023.
23. On 6th of
Please.
June.
Ready notice matters, seal number 29. Vaishali Agri.
Krishna, my lord. I pray for a passover, my lord. Senior is on his legs in another matter. Kindly pass over, my lord.
Let it go to another. Auction.
Auction matter, my lord. My security bid has been forfeited by the respondents, my lord.
We'll keep it on next Tuesday.
Grateful, my lord.
Number 30. Number 30, Mr. J.R. Mohan.
Which one? 30. 31.
30.
30. Keep it day after. Day after 2.
So 31 urgent. Number 32.
For the appellants.
32.
I pay for the appellants.
Pay for respondent number 3.
This relates to, my lord, the fishing rights in respect of, my lord, the Kabini River, my lord, which exists, my lord, near Mysore. What has happened is, my lord, earlier, a writ petition had been filed, where under, my lord, they were giving, my lord, leasehold, without, my lord, calling for auction. This honorable court, my lord, at page 168 had held that, my lord, there must be an auction. Thereafter, my lord, the government came up with the policy. My lords get that at page 129, my lord. At 130, sorry, 129, my lord, is the policy of the government now. which has been, my lord, brought into force with effect from 21 to 2014. Page 130, my lords, get the date.
139.
Yes, my lord.
120.
130, my lord. 130.
130.
131, my lord, if your lordships come to the next page. There are four types of, my lord, types of disposal. First, my lord, water resources shall be, my lord, A. Lease for a period of 5 years by inviting application for eligible fisheries cooperative societies. Fisheries cooperative societies which submit application shall meet the eligibility criteria, conditions specified in Annexure 1 and shall submit required documents. For each eligible fisheries cooperative society, subject to the jurisdiction approved in the bylaws, 2 tanks not exceeding a total water spread area of 300 hectares or 1 reservoir as listed in Annexure 2 and 2 river stretches shall be considered for leasing. What has happened is, they have given my lord, entire Kabini River, my lord, on lease to, my lord, this society, Respondent Society, for 5 years. Thereafter, my lord, Minister wrote a letter for renewal, and my lord, the director said it can't be renewed. Notwithstanding that, they have renewed it. That was challenged before the learned single judge. Learned single judge has dismissed the writ petition. Against that, we are before your lordships. In fact, it also provides, my lord, the scheme itself provides, the policy itself provides for, my lord, sorry.
So
Page
please,
1.
please read again, 131.
Yes, ma'am.
For each eligible fisheries cooperative.
Yes, ma'am. For each eligible, my lord, B, isn't it, my lord? My lords wanted me to read B. Yes. For each eligible fisheries cooperative society, subject to the jurisdiction approved in their bylaws, 2 tanks not exceeding total water spread area of 300 hectares or 1 reservoir as listed in Annexure 2 or 2 river stretches shall be considered for leasing in case only water resources having water spread area more than 300 hectares are available. Fisheries rights of only 1 water resource, then FCS shall be eligible for lease of only 1 water resource. In case of more than 1 FCS, that is, my lord, Fisheries Cooperative Society, having jurisdiction of tank, apply for lease, then priority shall be given to the village level Fisheries Cooperative Society, then Hobli level, Taluka level, district level, Fisheries Cooperative Societies limited, respectively. Then, my lord, can I persuade your lords turn to the next page? Last paragraph in the next page. Para 6. Period between 1st of July every year to 30th of June of next year is to be considered fisheries fastly year. Fishery rights either through lease or tender come auction is to be disposed of for a period of maximum 5 years. It was given to them for 5 years. Then, my lord, they, my lord, sought renewal. That, my lord, the director, my lord, rejects it. Please come to page 189. 189. At, my lord, 195, my lord, the English translation. Page, my lord, 198, if my lords come to, my lord, 198, last paragraph. The order was time-bound contract, that is, my lord, for 5 years. It expired, my lord, in 2002. It is limited up to the availability of the aid of National Fisheries Development Board with respect to community reservoir development aid provided by the National Fisheries Development Board has come to an end. And as the contract order period of the said reservoir would expire in the year 2015-16 as per your request, it is not permissible in law to extend the lease of the said reservoir from 2016 to 2020. Therefore, it is hereby informed that your memorandum cannot be entertained. Then, my lord, a minister writes a letter, next page, my lord, 201. The translation is at page 203. Sorry, my lord, my lords get that at page 205, my lord. 205. Memorandum and project report submitted by the Scheduled Tribe Fisheries Cooperative Society, Kabini, Hegada Devanekote Taluk, Mysore District to the Honorable Minister is enclosed herewith. I am directed by the Honorable Minister to request you to take action to verify and submit a proposal to continue the lease period of lease already granted to the applicant society for 15 years to develop Kabini Reservoir under Blue Revolution as a model for the state and to extend the lease for the remaining period. Based on this, my lord, they have extended, my lord, against which we are before your lordships. Learned single judge dismisses it. In fact, my lord, can I also persuade your lordship to look at the scheme, my lord, I mean, the policy for a minute. We are also entitled, my lord, ordinary fishermen, page 136, my lord, if your lordships come to. Ordinary fishermen are entitled to a license. 136. Para 15, my lord. Para 15. 136. Para 15, my lord. License fee for fishing in inland water bodies fixed by the Department of Fisheries. Details of the different types of fishing method. Fishing by 2 fishermen with the oracle using more than 2.5-inch mesh size gill net. 3,000 rupees, my lord, for the first 300 meters of length, etc., etc. My lord, then for estuaries, my lord, this is the payment. Annexure, my lord, 3 provides for, my lord, where, my lord, all these can be, these licenses can be obtained at page 141. 141. Kabini River, my lord, is one of those where, my lord, the ordinary fisherman can get, my lord, license from the government. The government does not give us license. It has, my lord, renewed the, my lord, lease in favor of the society. We are, my lord, poor fishermen, my lord, in that area. We are in the lurch. Therefore, my lord, we came before this honorable court. Learned single judge dismisses it on the ground. That, my lord, 2 grounds. One is, my lord, that they are a society. Second is, my lord, that I came late by about 4 months because 5 months, the lease, my lord, was renewed. I, my lord, did not know about the renewal of the lease. I came, my lord, before this honorable court, my lord, 7 months. 7 months. 7 months. All right, I stand corrected. 7 months. And therefore, my lord, the learned single judge says liable to be dismissed. It's the livelihood of the ordinary fisherman, my lord, which is at stake. License has to be given by the government, not by, my lord, the cooperative society. When we go there, my lord, they are not giving us anything. We have also filed an application before my lordships, my lord, to direct, my lord, the government to give us a license in terms of the policy itself.
So the area allotted exceeds 300.
It's the entire stretch, my lord, of the river itself, which runs into, my lord, several miles.
Then what is this paragraph of the single judge? In all fairness, page 36.
Yes,
Yes,
my lord.
we have offered,
No,
Lord.
no, no,
In fact, Lord, we
Agreed.
said, I'm a society, Lord, which basically consists of scheduled tribe, Lord, members. Lord, they are actually not interested in fishing, these petitioners. Lord, they are not set up by someone else. We have said, we have taken out paper publication after, Lord, the award of tender in our favor. We have said, anybody can come and, Lord, catch the fish. 50% of the, Lord, catch has to be given to us. 50% will be given to them. Lord, that was not the understanding as per the government order. So even now, Lord, after the order of the learned single judge, we have taken out a publication, but they don't want to come forward because, Lord, there's somebody else behind the back. For 7 months, they waited. Lord, we developed the entire Lord reservoir because government Lord felt individual fishermen cannot develop.
Ready to give participation to the petition.
Even for them, Lord. In fact, not immediately after, Lord, the order was passed in our favor, that society's favor. We took out paper publication saying that anybody who is interested, please come forward. But they did not come forward. They sat not quiet for over 7 months. And meanwhile, Lord, we have invested huge amount of money, including, Lord, we have 2 nominated directors from the government, not in the society. But if Lord, kindly permit me to just point out, Lord, the extent of development that we have undertaken. After we developed not the lake or reservoir, but these people started coming saying, no, but this third party who has some vested interest.
Lord,
kindly see, Lord, the paper publication that was taken out by us. And there is no explanation
license
for
has to be
this.
given by the government, not by Lord, the cooperative society. One. Secondly, my Lord, there is no answer for my Lord, more than 300 my Lord, hectares. They can't get a right. This, my Lord, it is not answered by the learned single judge.
That is not reflect, whatever submitting is not reflected in the order of learned.
It's not reflected, my Lord. That's true. That's precisely what I'm saying. We argued, and then, my Lord, it's not even considered.
Lord, kindly, my Lord, permit me take notes to the order of learned
Because
single judge.
question, my Lord, for your Lordship's consideration is whether, my Lord, this lease, renewal of the lease is proper. Minister, my Lord, director says it's not permissible, and my Lord, minister gives a letter, and then, my Lord, on that basis it is done.
Lord, that also has been considered by the learned single judge.
This contract is given for 5 years.
Lord, it is all, Lord, it's getting another 1 year, Lord, remains. Lord, 2019 is the order. Lord, we have already spent, Lord, almost, Lord, 5 years. Another, Lord, 1 year or 25, 26, Lord, is the lease. But even now, Lord, even they were taken paper publication. They cannot fish. As per the government order, Lord, they can fish. That is what learned single judge said. And they're not ready to take it. That's why learned single judge said, you're ready, please take this. But they're not ready because, Lord, there's someone else behind the back.
So they can fish in what manner?
Lord, they can, Lord, there is a government order. The government order says, Lord, the 50% value of the fish is not that is collected, that is fished by them. But what happens is in the reservoir, fish seedlings will be put by the society. But these fish seedlings, they take about 1.5 to 2.5 years to grow. But after the fish is grown, the fishermen go to the reservoir, catch the fish. Out of the fish that is caught, Lord, they are entitled for 50% of the value of the fish that they catch. And the rest 50 goes to society because we provide the seedlings. And the government felt individual fishermen, this being a large reservoir, they cannot develop the reservoir. And that is why the government, under Boer Revolution scheme, government felt, no, you can't develop individually. Therefore, it has to be given to a society which can develop it. But kindly permit me just show some photographs to show the kind of development that we have undertaken. But please permit to take my lords to my statement of objections. But can I request not to please turn to page 325 for a moment. But this is how the reservoir was, Lord, when it was given to us, page 325.
My Lord, Kabini River, my Lord, has always been a river with water, not, my Lord, a land-based.
I will point
greatest respect to my learned. I have also got there. I'm sure, my Lord, my learned companion judge also would have gone to Kabini.
Page 325.
We all go
then
there.
Please turn to page 327. But how entire structure has been changed. At page 329, but I have constructed multiple ponds. Page 329, should get it. But these ponds, everything is constructed so that the seedlings can grow, various varieties can grow. And in fact, the paper publication that I took out, please turn to page 332. In 2019 itself, I took out paper publication. Anybody interested, please come. But they did not come, they did not even come before the Honorable Court for over 7 months. They kept quiet. After the entire reservoirs were developed, but they started feeling, no, this is going to be a difficulty for the competitor. And that is when this petition is filed. But poor fishermen will not come to court in this fashion. So then please permit to take notes to the page 436 note. The subsequent developments also that have taken place. And my society has 2 government nominated directors. The bylaws also provide for it. And government has provided subsidy for the seedlings as well. Therefore, the entire purpose of filing the writ petition is not for fishermen. It is because there is somebody behind the back. But even now, Lord, they can come, Lord, and collect the fish. And Lord, as per the government's order, but they are entitled not 50% of the value.
So how will you be able to permit their entry?
But they'll have to register with us as Lord, the license is to be given from us, from the society.
They have got the license.
I can provide them, Lord, the license.
Mr.
They are not ready to come, Lord.
Lord, license has been given by the government, not by them, my lord. Please look at it.
Now,
Please
Lord,
see, my lord, page 136
that
of
is
the
the
very
entire
policy.
point.
Policy specifies.
Fishing is your livelihood.
Yes, my lord.
So then they are permitting.
Yeah, we are permitting, Lord. They don't want to take it.
My entire, my lord, 50%, my lord, I'll have to give it to them. Then what do I eat?
But I am the
If,
one
my
who
lord,
sows the
if-
fish. It is not them. Seedlings are not put by
But in a
me.
river, fish, my lord, always, my lord, is there. It's
No,
not
no,
that,
it
my
has
lord,
to be
they
seedlings have to be
keep
sold.
growing the fish there.
But
It's
I
not
would-
something.
But how to roll back now? It's very complex. You want us to set aside the contract and require the authority to retender it. That is what you.
Please, I'm in your lordship's hand. My lord, I understand. I understand that, my lord, so much of time has passed. Yes, I do concede now,
That is
because
the-
that, of course, is because after, my lord, but only thing is, my lord, it should not be repeated again. That's my difficulty. Tomorrow, my lord, again, my lord, they'll get one minister's letter. And that's my apprehension.
Lord, even Lord, under the Lord, the act, the policy, only a fishing society is entitled for fishing, Lord. Only the reservoir which is not otherwise leased, but individuals can come forward. And Lord, the petitioners, Lord, are individuals. They are not a society. They collectively hand few people who are selected not by this vested interest person.
That is not the policy. Policy, my lord, Annexure 13 specifically says, my lord.
Yes, Lord, I'll take notes of policy as well. Policy says, Lord, the area which is not leased out, which is available, Lord, that would be subject matter, Lord, of license. Lord, please permit take notes page 132 for a moment. And that is what Lord, learned single judge also, Lord, takes note of. Lord, page 131, Lord. Lords have seen the first priority is more for societies and for Lord by way of lease. Then Lord, please turn to page 132, Lord, subclause 3 there in licensing. In this method, permit is issued to professional fishermen or sports fishermen by fixing specified fees, place, and period to carry out fishing. Fishing shall be carried out only by issuing fishing license by levying fees, as mentioned in para 15 in selected reserves of the state. Reservoirs listed and so, all estuaries and rivers which are not leased. Therefore, Lord, first priority is for leasing, and Lord, kindly permit to take notes to the order of the government. This the order, Lord, is passed by the government, not saying that under Blue Revolution scheme, the entire thing has to be developed because it requires investment.
What was the prayer in the writ petition?
But writ petition, Lord, they wanted not set aside the order of Lord 2019.
You are granted pursuant to tender process.
Lord,
No, there was no tender, my lord.
Initially, Lord, tender was called for.
Renewed.
No, tender was called for and not
Pursuant
was
to
allotted
the
to us.
director said no renewal. Minister says, renew it. So based on the minister's letter, renew.
It is not based on minister's letter alone, Lord. It was not recommended for 15 years.
Prayer is at page 49. my lord.
You all are individuals.
Please, my lord.
We'll reiterate what is observed in the order regarding their willingness to permit you to enter and.
Lord.
fish.
Yes, Lord. As per the government order.
Can I?
Broadly, we are in agreement.
Please, Lord. If I have taken out paper publication also, Lord, after the order of the learned single judge. They have not come. They don't want to come because there's somebody else behind the back.
This is what you are reading about 300 meters or whatever is a part of the fishing policy.
Lord, can I?
It is not a statutory something.
Lord, then in that event, my lord, can they, my lord, then the question would be, can they, my lord, get, give, my lord, lease? My lord, please come to page 140. The entire, my lord, this 141, 6,092, my lord, hectares is, my lord, the water spread area. My lords get that at page 141. At the bottom, my lords get that, my lord, Kabini, serial number 33. It is 6,092 hectares. Therefore, my lord, they can't have, ultimately, my lord, these are all, my lord, public larges. It can't be given, my lord, at for the asking.
We'll just give a thought what to do.
Lord, can I request must please turn to page 225 for a moment?
Now you are given without tender.
No, my lord, tender was called for. Lord, recommendation was for 15 years. They gave it us initially for 5 years. That is in 2011. After which, my lord,
Already holding the license or whatever.
please, my lord,
Grant. You're already holding the right to.
lease.
Lease.
Lease license, lease is given to me. But then, Lord, what happened was, Lord, the director did not extend
Then
it.
at the time of renewal, minister recommended.
No,
There's
Minister
no
only
renewal.
says,
They sought for renewal. Director said it can't be renewed. Then, my lord, minister gives a letter.
no,
And based on
I'll,
that,
no,
my
my lord, it is not that way. Lord, what happened was,
Sure,
Lord,
your
then we
lordship.
approached this honorable court because the recommendation was for 15 years to give us, Lord, the lease. Because the director did not extend, we approached this honorable court. This honorable court granted us an interim order. And, Lord, we continued the fishing activities. Then, Lord, the government, we approached the government requesting, please look at the blue revolution policy. What was the object?
Where is your red petition? Your red petition. Copy
Please.
is there. Copy is there in this company.
Yes,
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 my lord.
it is.
Can I persuade your lordships to turn to, my lord, page 40, 39 it starts.
39.
39, my lord, 39.
Lord,
So
can-
who's your petition?
No, his petition, Lord, my
His petition.
appellant's petition.
So, Mr. Holla, this prayer B stands granted.
My lord, that has to be given by the government. We approach the government. They are not giving us. They say that approach them.
Now they are saying that you will permit you to carry out the fishing activity.
Yes.
Only difficulty is
But I have said,
50%, my lord, I'll have to give it to them.
Yes, Lord.
No, why?
But as per the government order itself, Lord, the fish seedlings are put by me, Lord.
It's a river, my lord.
But it's a river. It's a reservoir. It's not a river. It's a reservoir. But can I just request, Lord, so please turn to page 220 for a moment. Why the government passed this order? Lord, this was an exception made because, Lord, the reservoir, Lord, cannot be developed by individuals. Can I request, Lord, please turn to page 220 for a moment, Lord? It's a very detailed order. Why not this order was passed? Annexure H, Lord, which is subject matter of challenge before the learned single judge. Page 220, Lord, 220.
And my learned
Lord,
friend
can
said
I,
for 1 year, it is actually 2 more years, 2026.
25, 26.
Hmm.
This is 25, 20, 24, 25, 25, 26. But can I request, Lord, please turn to, Lord, page 221 of that order, Lord. Lord, the second paragraph onwards. Lord, it refers to Kabini Reservoir National Development Program, and the scheme was formulated initially for dash years 2011-12. Fishing right was granted subject to conditions, obligations. Further, he has stated that out of the 2 cooperative societies who have applied for grant of license of fishing, considering the fact that as per 2008 rules of Scheduled Tribe and other Traditional Forest Dwellers Act 2006, the dwellers of forest and Scheduled Tribe communities have a right to use the amenities available in forest and its vicinity. The committee formed to frame rules for development of fisheries has recommended that the lease of fishing right be granted to Scheduled Tribe fishermen, Cooperative Society Company, for a period of 15 years. However, as per the scheme of disposal of inland water resources, so and so, duration of 5 years is the limit. As per the plan action, as Kabini Reservoir is included in the list, so and so, reservoir identified to grant fishing license since aid of national fisheries development has been discontinued. Contract of fishing is not renewed for the year so and so. Questioning the same, the said society has filed WP number before the Honorable High Court, where an interim order was passed and based said order, society paid the contract license fee for the period so and so. Since said sort of withdrawn all the cases, reservoir is free for granting fishing license. Further, as per the present plan of action from the year 2019-20, fishing right reservoir is required to be issued. But as per Blue Revolution, as there is a provision to develop the reservoir under Comprehensive Reservoir Development Scheme, in order to comprehensively develop the said reservoir under Blue Revolution and considering the recommendation of Reservoir Development Committee, the society has requested to extend the lease by 15 years. Further, the said reservoir is constructed across Kabini River near so and so HT Kote, Mysore district, which has water coverage of 6092 hectares. During monsoon season, on account of sufficient inflow of water, reservoir will be filled to its capacity. Excess water will be allowed to flow to Kabini Reservoir. Project covers yes, Lord. That is why the government said, Lord, first priority is for society alone. Lord, that is there, Lord, in para 1, Lord, of the government fishing policy. Page 131, Lord. Para 1, Lord. First, my lords have it, Lord. Correct. Yes, Lord. That is all, Lord. Yes, Lord. More, in fact, not 5 years have passed.
No, it's all right. I understand, but
Yes, Lord. It is there in the order which the learned single judge record. I stand by it.
Can I seek only to indulge, two sentences I'll submit. Please come to 132 for a minute. I'll tell you lots is why. 132. License has been given by the government, not by them. Para 3, my lord, licensing. In this method, permit is issued to the professional fisherman or sports fisherman by fixing a specified fee, place and period to carry out fishing. Fishing shall be carried out only by issuing licenses by living fee, as mentioned in para 15, in selected reservoirs of the state. Reservoirs listed in Annexure 3 of this order. Please come to my lord, reservoir, my lord, Annexure 3, page 141. Kabini River Reservoir is one such. State has to give me, state doesn't give me.
The last portion of that para would be relevant, Lord.
And if you the order, 2016 it had ended. 4 years, my lord, they continue, my lord, without any license or lease. Thereafter, my lord, renewed for another 6 years, 7 years. Maximum period, my lord, is 5 years. Page 132.
But after I make all the investment of Lord, including Lord taking subsidies from the government, but they come forward and say Lord everything.
Not one paper has
even
been
today,
produced.
Lord, I have produced Lord, it is there. Government subsidy order is there. I have produced the bills, not amount of money that was spent, not for the project. I produced the bills, not annexure, not R4 and R5 are the bills. Great.
My lord, only one thing, my lord, I would one thing I would like, my lord, your lordship to my lord, lay stress is that, my lord, policy must be, my lord, strictly implemented. 5 years, my lord, is what it says. They have been, my lord, there for 10 years. 4 years without any contract, lease. Thereafter, 7 more years. Very well, my lord. I'm in your lordship's hands. Please, my lord, grateful to your lordship. No, I understand, my lord, that 4 years have lapsed. All that I
Great.
Please, my lord.
Great.
This is number 33, Mr. Yes, Nair.
And for the respondent number 5, my lord, kindly pray for short accommodation in this matter. And for the respondent number 5 in this matter, short accommodation.
Yes, lords, in this matter, my lords, your lordships, my lords, in the last occasion, directed the government, my lords, to take instructions with regard to what should happen to, my lords, making of payment or differential of, my lords, the pay scales during, my lords, the suspension order. And in fact, my lords, the observation made by the learned single judge, my lords, that there was an order passed in 2017. Based on that, my lords, since there was no challenge to it, it had become infructuous. My lords, against which, my lords, there is a writ petition filed. And, my lords, it is coming up on 10/6, my lords, 2024. My lords, this could be taken, my lords, after 10/6, my lords, 2024. Grateful.
Number 34, Mr. TP Mutana.
Can I please request for a passover?
I pray for the appellant, my lord.
Please.
My lord. My lord, this no, my lord, this is removal from service from compulsory retirement, my lord. And it's imposed, my lord, but this honorable affairs courts in 3 judgments say that it cannot be done. Because here, my lord, here that your lords may kindly see the orders of the learned single judge. There are only 2 issues. One is sympathy, another is financial loss has been caused to the bank. Now, no financial loss. But in fact, bank has written off crores of rupees because that it is there, my lord.
Can I please request for a passover? The senior is held up. Please.
First judgment, my lord, page number 10 and 11, page number 11. Page number 11, my lord. My lord.
High Court cannot substitute. the
No,
penalty.
here also same, my lord, High Court substituted.
therefore-
Substituted. The affairs court says, no, it is not correct because that it cannot be done. That is what this.
For the penalty aspect may be sent back to the disciplining authority. If the High Court is of the view that disproportionate, but High Court cannot substitute the penalty. That is the law.
That is what it says, my
Correct,
lord,
correct.
3 judgments.
Correct, that is what we are with you in that, on that line. That is the law. Well, you come whenever, when do you want?
Any date. Sir.
Back. The 3 judgments are of same.
So these are the judgments that the court cannot interfere in the quantum of punishment.
Quantum of punishment, my lord.
We want substitution of penalty.
I hear substitution only, my lord.
It is much,
First part I substituted only, removal of service substituted to compulsory retirement.
that is something much more, not for us. Will consider. Tenth June.
Please, Pablo.
Number 35. Sammaya HN.
I represent the appellant counsel. We have filed an application for additional documents as well as there is an application for condonation of delay. But the application for production of additional document is relevant for this reason. Our lands were subject matter of acquisition for setting up of a sewage treatment plant. Leonard Single Judge found that the
You're there?
Yes.
Ready to argue?
Lord, today itself, I got the letter from the TMC regarding they have already started construction of the sewage treatment plant. Just I want to verify that one, and I will, the next day I will.
The planning authority, which is Bayapath, this is situated very close to the international airport, now has given an endorsement that construction of a sewage treatment plant is not viable. Therefore, the project requires to be dropped. That is the document which I have now filed along with the additional document. If that could be taken into consideration by the respondents, I would only request that.
Will consider. 11th. Sorry, 11th. 11th to 12th. 12th of June.
Much of.
Number 36, frauds.
I appeal for
Krishna
the
Swami,
complaint,
yes.
Your Lordship's kind permission. My associate is also there before your lordships. My submission would be, my lords, I have filed 3 affidavits of the accused along with a memo for your lordship's kind consideration. They participated in the proceedings. They also filed affidavits stating that they would be depositing the amount.
20 lakhs deposit.
There was a direction by the learned single judge that the amount of rupees 20 lakhs has to be deposited within such a period, which has not been done. And the executive engineer, other engineers of the department undertook that they would do it by filing affidavit, which I have produced along with memo, which are pages 2 to 6 filed additionally.
Affidavits.
So today what is to be done?
Notice to be ordered. Notice to be ordered.
Notice to whom?
But I am not audible, my lords. Am I audible, my lord?
You're audible, but not visible.
There is an order by the learned single judge that rupees 20 lakhs will have to be deposited within a period of time, which has not been done so, my lord. And subsequently, the other executive engineer, they have participated in the proceedings that say that they will undertake. I have produced those documents along with additional memo
Today we accept this memo regarding office objects.
Your
Some
Lordship,
memo
may-
is filed regarding dealing with the office objects. You have filed it?
I'm for the complainant.
What do you say in this memo of
Lord,
counsel for the
they
complainant?
have to
submits
deposit
the-
20 lakhs, my lord, but they have not deposited
This is,
since.
this is contempt. What are the directions? Let us go to the root of it. What is to be complied with? Let
No,
us,
my lord, they have filed affidavit. We have filed affidavits, what they have filed in accused. That's all. my lord.
you are accused.
They have filed affidavits. my lord.
Who are you, complainant or accused?
Complainant.
Which are the directions to be complied with? Which directions are under contempt? Contempt is against which order?
Division bench, my lord.
Page?
Page 22, Annexure C.
Page?
22,
22. So read it.
Annexure C.
Page 23, read it. This court by order dated so and so and so. Equity will be met if equivalent for him to deposit. So what is the content? Madam, what is the content?
My lord,
What is the content?
they have not complied the order, my lord.
What is not done?
Deposit 20 lakhs.
Not deposit.
They have not deposited till now, my lord. Appeal bearing 309 of 22 dated 24/1/23, order was made to deposit 20 lakhs.
So delay is condoned. Delay is condoned.
Delay is not.
Company application is pending.
Yes, my lord.
Go there and complain about non-deposit.
No, because they have not
Contempt
complied the
jurisdiction.
order, my lord. They have not complied the order of
Will not
division.
exercise contempt jurisdiction.
They have not deposited 20 lakhs, my lord.
You argue there in the main petition to your favor. But this being an interim order will not exercise contempt jurisdiction. That is the only thing. By filing this contempt petition, non-compliance as well as contempt of the court are alleged in respect of the following directions issued by this court in company application number 309 of 2022. In interim application filed in company application number 309 of 22. Then page 24. Screen flap to be quoted. This court by order dated. Two aspects dissuades the court from exercising the contempt jurisdiction. Firstly, that the order complained of about non-compliance is an interim order. Also, the parent proceedings of the company petitioner evidently pending, admittedly pending before the competent court, before the court, to be considered on merits. Full stop. Secondly, there is no direction which could be subjected to contempt. What is observed is that the appellant is permitted to deposit a sum of those 20 lakhs before this court. In absence of direction from the court, non-deposit of the amount may not be reason to invoke the, could not be the reason to invoke the contempt jurisdiction. Full stop. The contempt petitioner may urge about the non-deposit of the amount independently in accordance with law at appropriate level. Full stop. The reason that there is no direction issued by the court which could be subjected to contempt, is a weightier reason than any other reason not to exercise the contempt jurisdiction. Full stop. Leaving the contempt petitioner at liberty to raise all the contentions before a single judge, in the company petition proceedings, to be considered in accordance with law and work out rights and remedies, the present contempt petition is disposed of as not entertained.
Number 37, so my
Direction of the learned single judge is to grant promotion as per the seniority list. Appellants were all persons who were working as senior health inspectors. And as per the seniority lists,
We have filed our compliance, partial compliance affidavit, my lords, on 6th April. Lords, wherein we have stated, my lords, that departmental committee has been conducted, PPC promotional committee was held on 10/4/23 and 18/5/2023, wherein a decision was taken, my lords, to promote the complainants to the grade of Chief Officer Grade 1. Lords, with regard to that, my lords, today, my lords, clarification from the Social Welfare Department, the meeting is scheduled, my lords. Once it is done, lords, thereafter, my lords, complete compliance will be done. We have filed this affidavit seeking for 4 months' time, my lords.
in this affidavit, they say that the person who is to pass order is on election duty. That is what at para
Filed
13 this.
April. Lordship may kindly see the last paragraph on page 6, wherein we have sought for 4 months' time. Para 8 of the affidavit also may be kindly seen, my lords, wherein the decision has been taken
It's here.
to promote the complainants.
How many persons are to be promoted? Only one?
There
Petition-
are about 12 of them.
Petitioners, yes,
Yes.
12. So all are promoted?
Lord's decision has been taken, my lords.
Where is that? Have you made that?
Para 8 of the.
8. I submit that they comply the intercession. Department Promotion Committee held on 10/4/23 and so on, has taken decision to give promotion from the cadre. So this should satisfy you.
No, Lord, they have downgraded the posts now. Lord, the entire grievance before the learned single judge was Our juniors have been promoted to the post of chief. Now they have downgraded our posts and said that we will give you the same posting. Therefore, let them pass an order and produce it before your lordship. This will be clear.
It is in their favor. We have downgraded the post to accommodate them because there was no
Correct,
vacancy, my lord. That should not come in their way. In fact, we have created the post to
So
accommodate
they are seeking the promotion to the post of
chief officer grade 1. And we have downgraded it from.
chief
commissioner-
officer grade 1
Please,
from
chief officer grade 2,
grade 2.
please.
They make chief officer grade 2 as chief officers grade 1 now.
No, no,
That
we
is-
have
Whereas our
downgraded.
juniors are now in the different chief officers.
We have downgraded the post of commissioner grade 2 to chief officer grade 1. Your lordship may kindly see, we have stated that in the affidavit. Commissioner grade 2, because there was no vacancy, we have downgraded the commissioner grade 2 to chief officer.
How you are concerned with?
Let them pass some order, let them place it on record.
We have
We'll go
taken
through that.
time, my lords. In fact, we have stated 4 months' time would be, please be granted to us.
Sir, this is in 4 months.
Lords, this was filed on April 6th, my lords.
4 months, how many months have passed? Only 1.
1.5 months, approximately 1 month, 20
So you are
days.
saying that decision is taken to give promotion from the cadre of chief officer grade 2 to grade 1, from the cadre of revenue officers and managers on the grade of seniorities. Now, according to you, this is the compliance of the direction. But
Yes,
only
my
orders,
towards
only
the-
orders are awaited.
Please, my lords.
Past
Today, my lords, I have the meeting scheduled. We are taking the clarification from the social welfare department regarding the reservation. All the promotions have to go to social welfare
Whatever
department.
you want to, you do. Whatever you. Unless you are clear, how can you make the code clear?
Let them place it before your lordship. Let us, if it is in satisfaction mode, we will. But it doesn't look so.
So we have this,
My instructions are, it doesn't look so. Anyway, let them.
So we have very clearly stated 4 months' time to comply the orders of this honorable court. It's on affidavit.
In this contempt petition filed under the Contempt of Courts Act, following directions were sought to be complied with, which were issued by a single judge in order dated 13 September 23, and quote from page 32, paragraph 3. In response to the notice, compliance affidavit is filed, in which it is inter alia stated thus, and the screen paragraph 8. Full stop. Thus, from the stand of the respondent, it is evident that the decision is already taken by the Departmental Promotion Committee to promote the petitioner to the post of Chief Officer Grade 1 from the post of Chief Officer Grade 2. Full stop. The decision would amount to a step towards compliance with the direction. What remains is the issuance of actual orders of promotion. Full stop. The court does not see any reason that the court does not see any reason that the issuance of actual orders of promotion should book any delay. Full stop. The respondents are directed to complete the exercise, to comply with the orders, comply with the directions of learner single judge before the next date put upon 18th July.
Very.
Number 38. Geeta Devi MP.
My lords, for the appellant in this case, my lords, this contempt is filed because the accused respondent has violated the orders.
Not served with the notice. So not served with the.
Yes, my lords, the notice is unserved and we have no,
So what shall we do? You take steps?
my lords, my lords, the respondent is currently taken a local residence in Bangalore because there's a WP order wherein he has a right to visit his son on every weekend, my lords. So he is himself taken a local address and he is in Bangalore, which I am furnishing through a memo. So we will take, if my lord permits, we'll take steps for the local address, my lords. And also, my lords,
Fresh notice. Learned, the endorsement on the board shows that the accused, that the respondent is not served. Full stop. When the petition comes, when the contempt application comes up for consideration, learned advocate Ms. Geetha Devi produces press address to submit that the notice may be served on such address. Full stop. The
my lords, I would
memo
also,
showing the memo containing the press address is taken on record. The registry is directed to issue press notice to the respondents on the address indicated in the memo, returnable on 18th July. Right?
my lords, I would also want to add, my lords, we have also served the copy on the counsel who is representing him in the WP, my lords. Acknowledgement of that also is furnished in the memo on the 4th page. So they are well aware about this contempt being filed, my lords.
Go copy to them.
We have served them, my lords. There's an acknowledgement by the advocate who is representing him in the WP matter.
Then what more we can do?
That's all. We'll take steps, my lords.
We can't catch hold of the.
Obliged, my lord.
Number 39, Muralidhar HM.
The accused 1 and 2, my lords.
Yes.
It's an office objection, my lords, that the documents filed along with the counter affidavit, they have not been attested. I seek a week's time for that, my lords. In addition to that, there is also a writ appeal filed in writ appeal number 445 of 2024, my lords. As on this day, my lords, the order stands complied, my lords.
Complied.
Please, my lords, the student has been attending the classes.
So result is declared.
Yes.
Admission is granted.
Please, my lords.
And they are
Please.
permitted to attend the class.
Please, my lords.
Done. Minor. Dispose of, will dispose it of?
No, I didn't.
So the council, your friend says that it is complied with. What do you say?
Even in our counter affidavit, we have specifically, my lords, contended that
We have understanding, your counterpart has to be.
the student is appearing,
Yeah.
take an admission in the
second
class.
So it is
semester she is appearing.
You are given admission or not, your client?
Yeah.
Given. So your client is permitted to attend the classes or not?
Yes, she is attending the class, but
Classes.
the first
He is
semester.
permitted to retain the benefit of writing first semester also.
Please, my lords.
So what remains?
No, till not declare the result, my lordship.
Even results have been declared, but the only difficulty was, my lords, she was required as per the order itself to approach the university and register herself for the next semester. Other than,
No, declare the result of this.
even we have declared the results
Where is that?
as well, but we have not produced that. yet.
Produce it.
No, my
Please.
lordship, it's not declared.
Please, we will clarify that, my lords. As far the results are concerned, we'll clarify that it has already been declared.
You produces.
Please, my lords. In fact, in addition to that, my lords, along with the counter affidavit, all other documents we have already produced.
Let us see.
Except the results, my lords. The declaration of the results, except the results. Results have been declared, documents have not produced, my lords. I will produce that as well.
So result of the first semester.
Yes, my lordship.
Please.
That is the main thing.
Please.
Otherwise tomorrow we'll say that she is failing in this first semester.
No, I'm informed that she has passed, but however, my lords, I will produce the document itself, my lords.
We don't understand. You comply or don't comply or challenge the order. But you produce the result.
Yeah, but I have not produced the results. I will produce that as well.
We'll produce the result.
Please, next week I'll produce.
Next date, next Monday,
Week after next, minutes.
next.
Please.
The directions of learner single judge to be complied with or in three faults. Firstly, the petitioner was to be permitted to retain her benefit of writing first semester BBA examination conducted in November, December 2023. Secondly, the respondent was required to declare the result of the first semester of the BBA. Thirdly, the petitioner student was to be given admission and further to be allowed to attend the classes of the second semester. Full stop. In course of the hearing today, paragraph, it transpired that the directions are complied with except that the result of the petitioner is not declared, which is the main aspect of compliance.
It's their
according to learned advocate for the complainant.
Please.
Full stop. I propose this grievance from a learned advocate, learned senior advocate, Mr. So-and-so stated that the result will be declared within 1 week. Right.
It has been declared in my information. However, I'll confirm with the document itself. My lords.
I propose the grievance, learned senior advocate, Mr. So-and-so stated.
I'm not a senior
That
advocate.
to his knowledge, the result is declared, but he would like to confirm the factum of declaration of result. For that purpose, full stop. He seeks time is granted, stand over to 3rd of June, full
Please.
stop. On that day, either the results will be produced or the compliance will be obtained.
Please. I'm not a senior advocate if my lords have noted as a senior advocate.
Pardon?
I'm not a senior advocate if my lords have noted it as a senior advocate.
Any objection?
I'm sorry. Writ appeal also may kindly be connected.
Don't write senior advocate.
Writ appeal minutes 445 of 2024. We may not even pursue with that seriously. Now that the fact that she
See
continues.
that if any serious impediment is there, you see that unless result is declared. So that.
Please. Right.
Because she is studying in the second semester without result of the first semester.
No, I am attending the classes for
That
second
is it.
semester, but
Don't know whether she is passing or not. Passing.
yes, have to know.
That is the whole thing.
Please. Right.
Number 40. Mr. M.K. Thomas, party in person.
Appearing for the state, my lord. Party in person.
Notice issued to the party in person is not served. Let the registry issue press notice, making it returnable on. What is it? PIL? Oh, acha. Simply adjourn. Not right. Simply adjourn after two months. It is PIL?
PIL, my lord.
PIL? What is
And
it?
since 2021, the notice, the petitioner has not been coming to court. The last order, 25/5/2021, daily orders, my lord.
This must not be surviving now.
Please, my lord.
Notice is not served.
Not so.
Not
How
so.
can we- Order was passed on 3/1/24. Inter alia directing the office to issue press notice to the petitioner party in person on the postal address supplied by him in the petition. Post of the party in person has not, paragraph, the party in person, learned party in person has not been appearing. Today also, when the petition was called out, none appeared. Full stop. In the larger interest of justice, stand over to. 30th July. Full stop. Registry may intimate the party in person about the next date of posting of the petition. Full stop. The court will be constrained to pass repetitive orders if on the next date the party in person fails to appear or fails to make any arrangement to pose appearance.
41, Shilpa Rani.
Petitioner, my lord, notice has been taken, my lord, it's not returned, my lord, it's 2 weeks may be granted.
Your office objection matters. These are not office. 41, what is to be done? Take steps.
Please, ma'am.
4 weeks.
You know, it shows my name for respondent number 4,
Yes.
but my lord, we have not been served with any copy or we don't know what is the matter about, my lord. Yes, my lord. My lord, my name is shown for respondent number 4, my lord.
Yes.
But my lord, no copy has been served and I am not aware about what is the matter about, my lord.
National Highway Authority, I have served that directly to office, my lord, if required, I'll submit one more copy to.
28-6. Number 42.
Appeal for a petitioner, my lords. This, my lords, the respondent number 5 has filed a report as well as statement of objection, clearly conceding, my lords, the report suggests that there is an encroachment. The public interest litigation is filed, my lords, alleging that the government land has been encroached illegally, my lords, and we sought for my lords' direction. My lords may kindly see the statement of objection filed by respondent number 5. Lord, very clearly, my lords, in paragraph 5, my lords, over the second page of the statement of objection, my lords, submitted, may I, my lords, lordship got submitted accordingly. Respondent number 6 conducted a survey of survey number through the taluk surveyor in the presence of petitioner, this respondent and respondent number 6, and submitted its report. That same is filed on 13/2/24. It is submitted that as per the survey report submitted by the respondent number 6, it is found that an area to an extent of 36 guntas in survey number 317 have been encroached by persons in possession of adjacent land. Submitted that on a suitable directions of this honorable court and by following process of law, this respondent will take necessary measures to remove the encroachments as per the survey. Lordship may direct this, my lords. On 13/2, a memo with the report was filed, my lords. Lordship permit, my lords, I have prepared a translation of that, my lords, for the able assistance of the court, my lords.
The translation is given with the.
Yes, they have given, my lords. I have prepared a sketch and translation that would make it clear.
You are for number 5.
R5, my lord.
Who is 5?
My
Which
lord?
is that also? Number 5, who is number 5?
It's Arsikare
Town
City
municipal.
Municipal Council, my lords.
Municipal council, my lord.
Municipal Council.
Municipal council.
Municipal Council.
Yes, my lord. We are
Commissioner.
Yes, my lord.
Arsikare city. Where is Arsikare? Is a town? Is a city?
It's a city in Hassan district,
Hassan.
my lords.
My lord, may I, my lord, memo report, page 1.
So you take, your report says that
There is a
36
encroachment.
juntas are
Yes,
encroached.
madam. There is.
So you
an
take your own steps. Why you shooting from the shoulder of the court? See this, it is submitted on the suitable direction from this court, and by following due process in this regard, respondent will take all necessary. You do it yourself. When you are yourself having a report by your own officer that there is an encroachment, why do you want court to issue directions? Are you powerless? This is not a good stand to be taken in court of law. You can frown upon immediately. But for your naive appearance.
My lord, because the case is pending, that's why we. My lord, because the case is pending, that's why.
What is pending?
This writ petition is pending. That's why we have not taken any
But this
expeditive
petition, the
action.
petition complained that there is an encroachment on some graveyard.
Yeah, yeah,
My
no,
lord,
my lord, it's a government land, my lord.
Government land. So you took out the report and found that there is an encroachment to the extent of 36 quintals. So take steps
We'll take steps, madam.
to remove the encroachment.
Yes, madam.
When you will take steps?
Will, at the earliest, madam.
Time limit. We'll give you the 4 weeks time.
Very well, my lord.
At least
We'll issue
6 weeks
notices.
time may be given, my lords, and it may be kept for complaints, my lords.
So this, what is the graveyard?
No, no, my lords, in that.
Is situated in 317?
Yes, my lord, 317, what and all are there as per the revenue records, my lords, I have stated. There to some extent graveyard is there, my lords. But remaining, my lords, in the government land, there is a private developer who has encroached upon.
36 juntas is in survey number 317.
317, yes. 317.
What is that? That is a government land?
That is a government land. It's a government land. In that, my lords, some portions.
Who has encroached?
My lords, I have specifically alleged, my lord, there are some private developer has encroached some portion of land, and my lords, some.
Any construction is there?
Yes, my lords, to some extent constructions are there, and my lords, and also there is, my lord, some persons have put in the.
My lord, survey number.
Have installed some crosses and all, my lords. I have brought in both the.
Yes.
My lord, survey number 520, there is a church. They have encroached the government land of 36 quintas, and the encroachment being that there is the symbol and cross symbol there. And that's the encroachment, my lord. So we will take necessary actions against them. My lord.
Remove the
By issuing note. Yes, ma'am.
in response to the present public interest petition from respondent number 5. That's the Commissioner of
Archeological City Municipal Court.
what was that?
Art-
Archeological City Municipal Corporation filed his statement of objections. Full stop. Therein following stand is taken. Then this saffron flap, paragraph 4, 5, 6, 4, 5, 6. Full stop. Thus, respondent 5 confirms that there is an encroachment of 36 gutas in survey number of 317, which is entirely a complaint. Complaint in this public interest litigation by the petitioner. Full stop. The encroachment found upon survey by the respondent number 5 is required to be removed.
Yes.
Full stop. Learned advocate Miss
Aarti.
Aarti. Full name.
Aarti B.
So and so, so and so. In response states, we want time. Don't want time. Then we'll record, then you'll be bound.
We'll follow.
If still you want to become surer, more confident, in a solid platform, without any fear or favor, then take instructions.
No, my lord, we'll follow necessary actions. We'll take.
States that the encroachment as found in the report will be removed by taking necessary steps and taking out measures within a period of
Yeah.
2 months.
Since how long you are practicing?
2 years, my lord.
2 years. You want time. Let him have the time. You take instructions, what can be done in view of the
Very well.
next Monday we'll keep.
Yeah.
You consult your commissioner and impress upon that in view of this, it is the
Fine,
duty of the
Ganesh.
commissioner to remove the encroachment. Otherwise, you might be in difficulty if your client doesn't believe you. Come on Monday, take instructions. We'll take upon Monday.
Number 43, Chaluraj GV.
Yes.
My lords, I ask for short accommodation of time, my lords. Senior is not keeping well, kindly accommodate a week's time, my lord.
What is it about?
It's with regard to the issue of environmental compensation. That's other issues which are not covered by the batch litigation which the Pollution Control Board is appearing before, my lords. So we have ready with
Environment, these matters are being grouped.
it's a bit different, my lords. Here, my lords, it's a bit different. I filed my objections. I'm filing it, my lords. If my lords may accept it now. Otherwise, I file it in the registry. I have it next week, my lords, because the senior spoke with me. He's having some difficulty. So my lords may have it next week.
Learned advocate Mr.
Mahesh Chaudhary.
Mahesh Chaudhary for the pollution board. File statement of objection, which is taken on record. Learned advocate Miss.
My lords, Harshita.
Pardon?
Harshita, yes.
Ishita. Ishita, give full name. Praise for time. When shall we keep? When shall we keep?
My lords, Tuesday, next Tuesday is fine, my lords.
After
4th. Fourth.
Fourth. Fourth.
Obliged, my lords.
Fourth, we know it is too short, but
That's okay. System number 44.
Have it on fifth, my lords. I just got to know election results are on fourth. Kindly have it on fifth, my lords.
fifth.
Yes, my
Fifth.
lord. Obliged, my lords.
Whatever issue you will accept.
Number 44.
Appear as the
Right.
amicus.
Yes.
Right. Annexure F. The petitioner was granted by a license for number C for establishment of a stone crusher unit, my lord, which is 15 kilometers away from KRS Dam, my lord.
Lords, in the connected
And one
petition,
second.
because I have not received this petition copy.
Right,
That's the reason
My
I'm
lord, the
making.
learned amicus curiae is only in the connected writ
Very
petition, my lord. He is there, not in this writ petition. Your lordship, kindly hear, my lord, by using your lordship's 8th of January 2000.
Any connected petition is there?
It's there before your lordships today.
That is there, a connected.
Where I am the
matter.
amicus, I was only submitting that in this matter, I have not received a copy. I'm in your lordship's hands.
Give copy.
My lord, I'll give the copy, just a minute. This,
You
Stone
want to
cr-
drive
I-
out, what are you talking?
no, no, I will
Amicus?
give the copy, my lord, to the learned amicus, sir. I have no problem.
You don't want to amicus to appear?
Absolutely, let him.
Then
yes,
give
yes.
copy.
I have
We'll
absolutely.
take up both the matters together.
Very well. Now, your lordship directed in the connect matter, directing them, my lord, to undertake the scientific study. What will be the area within which this buffer zone has to be maintained from the KRS Dam? My lord, they,
From?
Krishna Rajasagara Dam, my lord.
That is-
Yes, my lord.
20
Now,
kilometer
then,
injunction.
One second, my lord.
I think it was heard before.
Yes, my lord.
Lords, your lord, my friend does not mind because the amicus matter is also listed. Your lordships have issued an order, my lords, preventing any mining or allied activity within a radius of 20 kilometers. Pending, my lords, the state committee, which is a statutory committee under the Dam Safety Act, taking inputs from all agencies, my lords, and placing the report. I'm told that report is still awaited. That is the status, my lords, in the connected matter. In this matter, my lords,
Lord,
learned friend
in
may
fact,
make his
the report, my lord, your lordship, subsequently, your lordship fixed a time frame, my lord, for them to conduct a trial blast and the dam safety committee to take a
And
decision.
availability of report is.
My lord, that, my
material.
lord, my respectful submission, my lord, that order will not be applicable for the crusher units. That's what will be my respectful submission. my
When
lord.
the expert committee is considering.
My lord,
And the report is in the pipeline.
my lord,
Debating this, you will have no consequence.
my lord, I'll just, may I just.
Debate after the report is available.
My lord, I'll submit this, my lord. Your lordship intention was to protect the dam by those persons who use the blasting material by conducting the quarrying operations, my lord. Now, we are a stone crusher unit wherein, my lord, we carry on crushing of the stone, my lord. We don't use any blasting material. We buy the building stone 15, 20 kilometers away from different places, bring them, my lord, and carry on crushing operations, my lord. Now, this crushing operations, my lord, in any manner will not affect the KRS dam. That is the reason, my lord, your lordship's word last, my lord, allied activities intended to be the where, my lord, both crushing and quarrying activities going on. My respectful submission, my lord, if your lordship could see, my lord, in this case, the license granted was cancelled. This court granted an interim order directing them to permit me to carry on crushing operations.
When the-
That order
who is for
was
the-
challenged before the Honorable Supreme Court.
Who is for the government? Are you aware about the
Yes, sir.
likelihood of
Lord,
receipt of it?
My instructions are that, my lord, to conduct the trial blast, we need some time,
When report is likely to be available?
2 months' time. 2 months.
Well,
Because,
my-
my lord,
One other submission, if you lord.
Well, my-
the farmers who are living in that area, my lord, they are obstructing to conduct trial blast.
From what I've gathered from my learned friend's submission without the papers, that he is a stone crushing unit. Now, your lordships, my lords, in WP 5990 of 24, by an order dated 28/3/24, which I will place, have directed an identical stone crusher, my lords, to approach the committee by way of an application and for the committee, my lords, to take a considered decision in the matter.
Get the order.
That is, my lords, you have a hard copy? Lords, I'm sorry, I only have a soft copy of the order. That is, my lords, 5990.
Right, I have a slightly and distinction, my lord. Kindly see the order, my lord. Order of the Honorable Supreme Court, my lord.
I just give the order numbers.
Yes.
WP 5990 of 2024, my lords. Your lordships order dated 28/3/2024. Permit me, may I pass on, my lords, a soft copy? I'm sorry, I didn't bring it.
Now you get the, if it is available.
28/3/24.
But then this, all such petitions may follow the same course.
Quite so.
My respectful submission, kindly see the order of the, this division bench of this honorable court, page 100, my lord, for a minute. By relying on, my lord, subsequent interim order of lordships, can they override the earlier interim order granted by your lordship? Page 100 for a minute. The division bench of this court, my lord. Yes. The division bench of this court has granted an interim order, so and so, same is continued.
The committee has power to permit the continuance of the activity.
No, my lords, your lordships have only observed that the committee will review whether the activity is one that endangers the dam in any way. And that report would come before your lordships.
Today your unit is not running.
And because of your, contrary to orders, my lord, your lordship granted an interim order that was challenged before the Honorable Supreme Court. The Supreme Court upheld the interim order. My lord, they are relying on the subsequent orders of your lordships, my lord, and then preventing me from conducting crushing operations, my lord.
Please see para 2, my lords. This was also by a district stone crusher licensing and regulatory authority.
You have gone through this order?
My lord, I have not gone through, my lord, but yes, let's see. The earlier order of the Supreme Court.
I am not in an adversarial position to my friend. You should not mind my appearing and assisting.
No, I am not feeling this thing adversarial, my lord. Now the question is, my lord, your lordships may kindly see, in fact, in the 8/1/2024 order, my lord, page 112, your lordships observed, my lord, para V, my lord.
Same.
Yes. Right. Kindly see, well, 112, I'll bring to your lordship notice. Kindly, 1 minute. The last, your lordship's order, which is the basis, my lord, I'll only 1 minute.
Yes, sir.
If any difficulty arises in giving effect to this interim direction, any person can move this court seeking appropriate orders. Similarly, after the study and research is submitted, statutory committee is open to the parties, the petition. Now, in this case, my lord, I am moving your lordships for this reason. Your lordship's order directing to stop the crushing of, there is no order, my lord, because of the word allied activity, they stop the crushing operation, my lord. The crushing operation will not even affect the neighboring land. These are all the crushers which are 15 kilometers away from the KRS dam, my lord. Now we are employing hundreds of people in crushing activities, my lord. We have taken electricity. We are paying minimum consumption charges, my lord, which is affecting, my lord, large number of persons, my lord. I understand, my lord, in so far as the quarrying activity is concerned, madam, your lordships were of the view that conducting quarrying operations and the consequent vibration may have an effect on the safety of the KRS dam. But in so far as the present, my lord, this, my respectful submission, my lord, your lordships only observed that, my lord, therefore I pray this court, my lord, to clarify in that, my lord, this order will not come in the way of a stone crusher units, my lord. Your lordship intended, my lord, that there are some stone crusher and the quarries in one particular place. So that was the intention of this honorable court, taking the view, my lord, that the allied activities, my lord. Now this stone crushing activity, with due respect, I submit, my lord, it is affecting thousands and thousands of people, which is not going to affect the KRS dam. My lord, in so far as a scientific study, my lord, your lordships already in the connected matter set a time frame, my lord, for completing the scientific study. My lord, till today, the trial blast was conducted, some individual protested, the deputy commissioner did not give the protection, and the trial blast is not conducted. We are back to 0-1, my lord.
When you will argue, other than today?
Any time, your lordship.
Tell the date. Tell the date.
Tomorrow, they are convenient to me.
Tomorrow is too early.
Please.
Monday?
Monday, please.
Monday is convenient?
As your lordship.
Yes.
Report has to be filed. Report is to be filed.
You argue after report, he will argue before it.
And what happened in the connected matter, my lord? In the connected matter, I had filed an application seeking implement. I am the complainant because of which the issue started. On the previous date of hearing,
The
my
lordships
lordship,
rejected his application,
No,
my
no.
lord, asking
The
him to
application
go
wa-
before the committee.
You want to argue before availability of report?
My
So,
lord,
argue on Monday there.
Please, my lord.
Obliged.
Case number 45. H.M. Muralidhar.
For the petitioner.
Yes. Delays. there.
Other two matters were, yesterday was that is posted on 3/6, my lordship. So this has to be
3/6, not 3/6, then it will go to 10/6.
10/6. But connected matter and posted on.
They will go on 10/6 on third. Yes. Yes, next.
Number 46. PC Sunita.
Awaiting service of notice.
Service.
I undertake to appear for respondent number 1 minutes.
R6 and 7 is also necessary. part.
Service is awaited, let it.
Please, madam, please, I'll take.
You are appearing.
Appellant, I am appearing, my lord. R6 and R7 notices to me. Gone, my lord, waiting until,
So service of notice is not necessary.
not yet completed, my lord.
So you are appearing.
It's necessary parties, my lord. R6 and 7 are necessary parties. Much obliged.
Nothing. Let the appeal await the service. Service of notice. To be posted on 28 June.
Much obliged.
Number 47. So government appeal.
2 weeks time.
Number 48.
For the
Appeal by
appellants in this
SCA.
case, Lord.
Yes.
We have challenged the acquisition proceedings. The learned single judge has passed the order, though conceding that the award is not properly passed. Dismiss the petition only on the ground of delay and latches. Probably the delay and latches do not come. This matter had come up before the vacation bench, my lord. This honorable court was pleased to direct the notice to the respondent. Respondents appeared before this honorable court and they undertook to file their statements of objections. And also given the undertaking that they will not put up construction. My case is, this is a matter which falls within the ambit of the law laid down by the Apex Court in the Indoor Development Authority's case. Here, the award is not passed in accordance with law. The possession of land is also not taken by the acquiring authority. And based on an agreement alleged to have been entered into by the society with the landowner, they said that the partly amount has been paid as per the consent award which they have shown. That is not the award in the AF law. The division bench of this honorable court has taken a clear view that any amount is paid in prior to the declaration, prior to the initiation of acquisition proceedings, is no payment, and award is also not award. Lord, so far as the position of land is concerned, we have taken the photographs. Lord, Google photograph, the entire land is not developed. I may be permitted to show the location of the land. just 10 or 12 kilometers from here, my lord, no development is done. The land is still as an agricultural land.
May I submit, my lords? My lords, the preliminary notification, my lords, is 15/4/1988. That was in the favor of third respondent, Aircraft House Building Employees Society, my lords. 89 is the final notification. In the year 1990, consent award was passed, my lords. My lords, this is a case where much water has flown under the bridge, my lords. Allotments have been made, and my lords, in fact, for the party who am appearing is a purchaser from the allotee, my lords. There are several the society has allotted sites to various persons, and the fifth respondent before my lords is one of the purchasers from the allottees. And this very petitioner, my lords, has gone ahead and executed a confirmation deed in favor of an allotee of the society. Your lordship may kindly see the confirmation deed, which your lordship will get.
For one person, a confirmation deed.
Nevertheless,
their request.
if my lords, after indoor development case, my lords, only 2 grounds are available. They have to satisfy that both award is not passed and possession is not taken. So far as award is concerned, my lords, there is a document to show that 50,000 check was given to the petitioner's mother. My lords, the land was acquired in favor of the petitioner's mother in the year 1988. 89 is the final notification. All along till 2000, when allotments were going on, the petitioners remained silent. In 2000, my lords, they create a partition deed amongst themselves, and that partition is marked as Annexure C to the writ petition. In the partition deed, they project as if this land has fallen to the share of the petitioner. From 2000, they start the litigation. My lords, petitioner's mother, who is the best available witness to say whether she has received the money or not, or to lay challenge to this consent award, she is not there. After her demise, this litigation starts, my lords. Now, my lords, when they file in the year, this writ petition is filed in the year 2015. When they file, they take a ground that consent award is not passed within the time stipulated under section 12 of the Land Acquisition Act. Therefore, since the award is beyond the time period, the award is bad in law. Therefore, acquisition is bad in law. That was the preliminary ground. In the year 2023, they make an amendment to the writ petition. They file an amendment application to the writ petition on the ground that the consent award itself is bad in law because she has not consented at all. This award is with fraud. My lords, in 2024, they make this. Therefore, my lords, I file my objections to their application saying this. Not only the writ petition is with delay and latches, this application seeking for amendment is even more bald and is hit with delay and latches. Therefore, my lord, the learned single judge considers all these factors and finds that there are allotments and she has received the consent award. And therefore, it sets the petitioner saying that the petition is hit with delay and latches. My lords, in the very same notifications, my lords, were challenged by other landowners, and the matter reached up to Supreme Court. Supreme Court, my lords, has confirmed the acquisition. One document, my lords, may show.
We have come not an acquisition. We are coming before this honorable court under section 24, subsection 2.
Section 24 is not available to them. The acquisition is of their 88,
because
89.
I can demonstrate. Because we have never allowed them to enter upon our land. Even the land, let the commissioner be appointed. Entire land is vacant.
Only one
no
document
layout is formed. No site is formed. No drain, no road.
We'll hear on some other day. It will take time. Your time to rise.
Please.
Lord, the interim order may have to be
Lord,
extended.
Lord,
Lord,
that was
because in the
undertaken.
Interim order is passed.
Yes,
Lord, it was
interim
an
order.
undertaking given because of the vacation bench, my lord, because of the pressure before the vacation bench.
They have given the undertaking before this honorable court.
that
Till
we
the
are-
next
we are-
date appearing, they will not put up construction. Let that interim order be, let there be an order of status quo, because I can demonstrate before your lordship that land is still as it is. No development, no site, no road, no drain. Your lordship may kindly peruse the photographs and also Google photograph I have taken. This is very much visible. Your lordship may kindly see the photograph.
You can argue from here also.
Google photograph. And the live photographs also.
Without serving these copies, my lords, this way I don't.
It's a, we have
My
protected.
lords, we are
There was
there
a
throughout. We
judgment
are
and
on
decree.
KV8.
There was a judgment and decree in a suit.
At least we are also entitled for a copy of the
And
documents
that
which
was
now they are
challenged
facing.
before this honorable court in RFA. RFA said by following the bridges to the gas. So we have been given liberty to approach this honorable court under writ jurisdiction.
You are the only counsel who doesn't need the mic. Lord. We'll take up on some other day, Mr. Counsel.
Let there be an interim order, because
But if it is
there
there-
is threat of construction.
If it is there, we'll extend. If it is not there, we'll not grant.
Yes, my lord,
It's an
it is there.
undertaking given by
May I
us.
read, my lord? The learned counsel for the respondent, see, I will read. The learned counsel for the appellant submits that the appellant writ petition had the benefit of the interim order of status quo, which was in force till the writ petition was ultimately dismissed via the impugned order dated 6/2/2024. It is submitted that subsequently the respondent 3 to 5 are attempting to put up construction over the suit property. As such, the appellant was constrained to file IA number 124 for temporary injunction. The learned counsel for the respondent number 3 as well as their counsel for the respondent 4 and 5 seeks time to file objections to IA number 4. It is also submitted till the next date of hearing without prejudice to their rights and contentions. Respondent 3 to 5 would not put up any further construction on the suit property.
That is fair enough. Don't put up any, don't create any equity. So we'll
Any
take up.
any shortest date, my lord.
That is the reason, my lord, let there be an order of status.
No, this undertaking which is
Status
there, we will undertake to continue this undertaking.
27th June,
Please,
Status quo as on this day.
my lords, we will undertake to
whatever
continue this
order is
undertaking.
passed will continue.
Please, please.
Send out to 27th of June, order passed on 20/24 by the court shall continue to operate till the next day.
Please.
Serial number 50, madam. I may not take more than 10 seconds.
10 seconds is over.
No. Notice may be ordered for the accused number 3 and 7, except the other accused.
You want press notice? Press notice to this 1, 3 and 7. Returnable on? Returnable on somewhere in July, 4th July.
Please.
My lord, serial number 53, my lord, I'll take just 5 seconds. There is an office objection. I've made a submission there that directors of the company must be mentioned, but they have been made parties, my lord, already. So that office objection may be overruled. The contempt will come on top of the list. My lord.
Office objection, which serial number?
53, my lord.
53. Office objection with regard to?
With regard to council submission, my lord. I've written a council submission.
Regarding the name of the directors to be incorporated in the.
Which is already incorporated.
Please
Accused one.
dispense with, as the names are already incorporated.
My lords, serial number 55. Short date may be given here. Serial number 55, I have sought for interim order in this writ petition, my lord, because it is a greenbelt area, construction is going on. The industry is set up, my lord, that's a matter is very urgent, a short date.
We'll take up on 11th June.
My lords, item number 59, my lords.
11th June, subject to removal of office. Yes, anything?
My lord,
No.
serial
My
number
lord.
58.
Serial
number 56, my lord. I am for the response.
Yes, Sika.
There is serial number 56 appearing online,
Yes,
and I believe your lordship is raising now. Then a nearest possible date, my lord, maybe little top on the list so that it will reach. Last time also it did not reach.
whichever date you want. It can go to 26th of June.
No, maybe little early, my lord. Maybe little, if I have an option is to, I will say tomorrow, but some near date.
Nearer date, will not be
Nearer.
possible, Mr.
Because it's been pending for pretty long time and many times it came and it was never taken up.
18th June.
18.
My lord, in serial number 56, I am for the caveator, my lord. They
Yes,
have
one
served
by-
incomplete
one
copy.
after, yes.
Serial number 59, my lord, appearing for petitioner. There is some urgency, my lord, may be taken up on Monday, my lord.
Remove the office objection.
I'll complete it by tomorrow, my lord, maybe taken up on Monday, my lord.
Then mention.
Meet the council submission, my lord. That those are the documents, receipts of the pension payment, my lord. Written the council submission, that may be overruled, my lord. And have
That is the only objection.
My lord?
That is the only objection.
Yeah.
So objection regarding Type copy of pension
Yeah,
payment order.
translation copy, my lord.
Pension payment order is dispensed with.
My lord, have it on next week, my lord. Kindly have it on next week, my lord.
That will do.
My lord, in
That
serial
will
number
be
56,
listed.
my lord.
I am appearing in 61, I have put the appeal on, very urgent matter, I have to challenge on the civil just order. It will be given in next week. In the meantime, I will comply. to
Date will be given by learned court master, court officer, yes.
My lord, in serial number
Some date-
56,
some
my
date
lord,
may
I
be
am,
fixed, my lord.
It will
Some
be
date-
given.
Some date may be fixed in 1961.
It will be given. It will be given by court officer.
my lord, in serial number 56, my lord, which your lordship posted on 18th
Will
June.
not break the line. Yes, madam.
53 fresh contempt, my lords have said that the officer will give the date.
Yes.
My lord, in that matter, my lord, they have served incomplete copy to me, my lord. I am the curator. They may be directed to serve a fresh copy.
You not, you seek your help.
My
You
lord.
approach your learned and yes.
My lord, serial number 58, my lord. My lord, I am filing, I am for the respondent, curator, my lord. I have filed contempt petition, my lord. Post along with contempt petition. Contempt 88 of 24, my lord. Along with the WA number 151 of 24.
What do you?
They filed a writ petition by the government, my lord.
So both together to be listed after 2 weeks. Yes.
Otherwise, the copy is not served, my lord.
Yes, Mr. Jack.